Senator Cruz, it's your turn now.
Thank you, Mr. Chairman. Judge Gorsuch, congratulations on making it through more than half of a long day and making it through with flying colors. I think this hearing has been helpful for illustrating the proper temperament and approach that we should expect of a federal judge, and I think you are acquitting yourself in an excellent manner. This hearing is focused on a lot of weighty matters, so let me start with something lighter and a topic on which I believe you have some familiarity. What is the answer to the ultimate question of life, the universe, and everything?
42.
Thank you, Judge. And for those who are watching who may be a bit confused at this exchange, could you explain what it is to which we're referencing?
Well, Senator, sometimes we have young people who come to court to be sworn in. Often they're my law clerks. There are a couple of them right there. They haven't enjoyed this privilege yet. And they come to court and they're very nervous. And the clerk tells us about their career and their record, then submits them to the court. I move their admission to the bar. Are there any questions from the bench? And it's sort of like this. It's a bit intimidating. This has been a reminder to me of what it's like to be down here rather than up there. And the last time I had this kind of interaction with Senator Lee, it was when he was down here and I was up there. At any rate, I sometimes ask them that question to put them at ease. And they all know the answer, and they all know the answer because they've all read Douglas Adams' Hitchhiker's Guide to the Galaxy. And if you haven't read it, you should. It may be one of my daughter's favorite books, and so that's a family joke.
Well, it is a book I very much enjoyed as well, and it is, I think, a delightful example of the humanity of a judge that your record has demonstrated. You began your career with the opportunity to serve as a law clerk to Byron White. Byron White is an extraordinary man. Byron White was the only justice that John F. Kennedy put on the Supreme Court. Byron White is, I believe, in fact, I'm quite certain, the only Supreme Court justice in history to lead the NFL in rushing, and also to graduate first in his class from Yale Law School. Could you share with this committee what it was like to be a law clerk for Byron White and to interact with him every day during your clerkship?
You know, as I said, he really was my childhood hero. And to actually get picked out of the pile, to spend a year with him, as Senator Lee's dad did, that's something we share in common too, was and remains the privilege of a lifetime. And it has everything to do with why I'm here. I wouldn't have become a judge but for watching his example. And the humility with which he approached the job. And I don't mean a phony humility. I mean real humility. Every day. He always said 2 heads were better than 1. He'd sit down in my office, plunk himself down in a chair across the desk. We'd be talking about a case and say, Always started with a grunt. I mean, that's how he started a conversation. It was like, hello. So what does the great Justice Gorsuch think about this one? And you were expected to have a view about pretty much anything and everything that he asked. And he'd just sit there and chuckle at you. And he'd laugh at you. And you're wondering what he thought. He never revealed his hand. And he'd just walk out of the office saying, oh, that's what Justice Gorsuch thinks. Okay. And then he'd go back and he'd think about it himself. And then he'd come back in again. And the whole thing would repeat itself. As he was working through each case himself, he'd want to bounce ideas off of this know-nothing 20-something-year-old kid. And that, to me, taught me everything about what it means to be a judge. And the fact that when asked his judicial philosophy in this sort of setting, he said it's to decide cases. And I know a lot of people think that's just mundane or maybe cover dishonesty in some way. It's just not true. It was the humility of the man. That he knew that lawyers worked really hard because he had been a lawyer, a workaday lawyer for 14 years, I think it was, in a law firm. He tried cases, small cases, big cases. And he knew what it was like to have to be the lawyer in the well and how hard it is to have all the answers, how easy it is to ask the questions.
Now, you and I both had the experience of clerking at the Supreme Court after Justice White had ended his time on the basketball court.
Yeah.
Or maybe you were luckier than I. For those who do not know, above the Supreme Court, above the roof of the courtroom, is a basketball court, which is referred to tongue-in-cheek as the highest court in the land. And Justice White, for many years, would play in the basketball games, NFL Hall of Fame football player with a bunch of pencil-neck law clerks.
Yep.
And his elbows and fouls were legendary. When I was clerking, he was no longer playing. Perhaps, were you lucky enough to get him up on the basketball court?
He would come up for a game of horse with the clerks, former law clerks at reunions.
How's his jump shot?
His best shot at that age, we're talking in his 70s, late 70s, was from the free throw line back up over his head like that. And he could hit it pretty regularly. His eye-hand coordination was just uncanny. So I remember those law clerk reunions at the basketball court where he'd come up and stiffly throw it up and sink it. And I remember walking through him in the basement, arm in arm. Like to walk arm in arm at that age. And we'd walk past all the portraits of all the former Supreme Court justices, which are down in the ground level. And he'd ask me, Ron, how many of these guys you honestly recognize? And I was one of those pencil-neck law clerks. And the truth was, I thought I knew a lot about the Supreme Court, the law. And the answer was about half, the honest answer. And he said, me too. And he said, the truth is, we'll all be forgotten soon enough, me included. And I remember saying, Justice, that's impossible. You're one of the greats. No way you're going to be forgotten. His portrait now hangs down in the basement.
Well, there is wisdom in that humility. Let's shift to another topic, a topic that has been raised some in this hearing, which is there are some Democratic senators on this committee who have raised a challenge to the notion of originalism, and indeed have painted originalism as some quaint and outdated mode of interpreting the Constitution, have suggested that their view of the Constitution, it is a living, breathing, changing document, flexible enough to accommodate whatever policy outcome the particular judge might desire. The alternative is that a judge is obliged to follow the Constitution, the text of the Constitution, as informed by the original understanding at the time it was adopted. Do you share the view of the Democratic attacks that originalism is somehow a quaint and outdated notion of reading the Constitution for what it says?
Senator, I want to say a few things about that, and I appreciate the opportunity. The first is that sometimes we, in our discourse today, our civil discourse, use labels as a way to not engage with other people, to treat and divide us and them. And as a judge, I just don't think that's a very fair or appropriate or useful way to engage in discourse. So I'm worried about using labels in ways that are sometimes an excuse for engagement with the ideas, sometimes pejoratively. The truth is, I don't think there's a judge alive who doesn't want to know about whatever legal text he or she is charged with interpreting, something about its original meaning as enacted. And I don't think this is an ideological thing. I look at decisions like Jones, which we've talked about, or decisions like Kylo, the thermal imaging of a home. Is that a search under the Fourth Amendment? The Supreme Court goes back and looks at the original history and says it's equivalent to peeping toms, which of course would be a search under the Fourth Amendment. The Constitution is no less protective today of the people's liberties than it was 200 years ago. Or when we look at Crawford and the right to confront witnesses and not just have pieces of paper flying in evidence that you can't confront reasonably, to cross-examine your opponent, fundamental right of the Sixth Amendment. Look back to the original understanding. That informs us. Or in the Fifth Amendment, Justice Stevens in Apprendi wrote a very fine examination of the original history of the Constitution and said it's not right that an individual should be sentenced to prison and then a hand sentence on the basis of facts a jury hasn't found. Those are all originalist, if you want to put that label on it, opinions, every one of them. You could look at Powell versus McCormick about the qualifications of members of Congress. That was written by Chief Justice Warren. It's a very careful, we might agree or disagree with it, but it's a very careful examination of the original history and understanding of the relevant provisions of the Constitution. Or Heller, Second Amendment case. Justice Scalia and Justice Stevens both, the majority and dissent, wrote opinions that are profoundly thoughtful in examining the original history of the Constitution. I guess I'm with so many other people who've come before me, Justice Story, Justice Black, and yes, Justice Kagan, who, sitting at this table, said we're all originalists in this sense. And I believe we are.
Well, Judge, I thank you for that very scholarly and erudite answer. You are right that Justice Kagan gave an answer that had many similar aspects and said, we apply what they say, what they meant to do. So in that sense, we are all originalists. And, you know, you referenced the Kylo case. I think it serves well to rebut the caricature that some on the left try to paint of originalism. They're dealing with thermal imaging. You know, the notion that, gosh, how could the framers possibly imagine modern contrivances, modern contraptions? Well, thermal imaging did not exist in the 1700s. Right. The framers had no idea what it was. And so under the caricature that some of the Democrats have suggested, you would assume the originalists in the case would all line up on the side of saying, well, gosh, the Fourth Amendment doesn't cover that. And yet the Kylo case, the majority opinion, 5-4, was written by Justice Scalia, perhaps the leading originalist on the court. It was joined by Justice Thomas. And indeed, Justice Stevens dissented in that case. And so I think that case illustrates that any judge doing his or her job, a thorough understanding of the original understanding of the language is essential to effectively doing your job. Would you share your thoughts about how the Constitution intersects with modern technology, how a 200-plus-year-old document can possibly be applied in a world of internet and technology and changing reality?
Well, it's just these discussions we've been having, right? You go back and you look to the evidence of what it was understood at the time to protect. Of course, Madison didn't know about thermal imaging or GPS tracking devices or DNA or email. And no one is looking to take us back to the horse and buggy day or quill pens or to turn back the clock on anything. The point is to apply the law in a way that allows us to be able to say as judges, it's not what we wish. It's what the law was understood to mean. It has a fixed meaning, as Madison said, in the fixed meaning canon of construction, that the Constitution should have a fixed meaning, all right? And the judges may disagree over what that is. We disagree once in a while, not as often as some would like to portray, once in a while. But our disagreements are not political disagreements. They're disagreements over what the law is. That's very important to me. And the other thing it does is it's a due process value. We're interpreting the law in a way that we can charge people with notice of because we're judging them for their past conduct. People lose their liberty, their property, on the basis of our interpretations of the law. And it seems to me that it should only be fair that there are interpretations we can charge them with notice of. Right? Similar thing when we come to statutory interpretation. Right? What does that text mean? What could a reasonable reader understand that text to mean? You know, my favorite case in statutory interpretation when I teach this stuff and talk to my law clerks about it is the fish case. You know, that there the statute read something like, and I'm not going to get it exactly right, but if you destroy email, documents, or other tangible objects when you know the cops are after you, you go to jail. Well, what does that mean in the context of a fisherman who knows the Coast Guard's after him and he's got an illegal catch and he throws it overboard? That case went to the United States Supreme Court. It's a great case. And it divided in a way that people don't expect, right? Justice Ginsburg wrote the majority opinion, and along with Justice Alito writing a concurrence, saying, fish, this statute's about email. Nah, no notice. Justice Kagan and Justice Scalia wrote a dissent saying, fish, that's a tangible object, right? He had notice. He shouldn't have done it. And so these things don't divide along any kind of ordinary ideological line. I am confident that there are justices who in that case, or in Heller, or in any of these cases, would, as a matter of policy, have come out differently than they did as a matter of judging. And that, to me, is all the difference in the world. We're not doing what we would like, but what we think the law is.
Let's turn to another topic. Some of my colleagues on the Democratic side have raised some questions about the Federalist Society and have raised it with a tone that suggests it is some nefarious and secret organization. Indeed, I was waiting to see the question, are you now or have you ever been a member of the Federalist Society? And given that context, for the sake of candor, I'll go ahead and self-report now. I am and have been a member of the Federalist Society since I was 21 years old and a first-year law student when I happily joined. And indeed, there are over 60,000 members, law students and lawyers, and indeed those just interested in the Constitution and the rule of law. And one of the things that has struck me about the Federalist Society is the incredible range and diversity of opinions within the Federalist Society. You have conservatives, you have libertarians, you have those who believe in fidelity to law and wouldn't ascribe to either of those labels. And I understand you gave a talk at a Federalist Society event at the problems of overcriminalization. Can you tell us a bit about that talk?
Yeah, I think it's fun to go into audiences and challenge them sometimes a bit. I think it's important. And as to the Federalist Society, I don't have a card either. And I really don't want a back statement for past due dues. But I attend maybe one event a year or something like that. It's all on my forums that you all have. And at that speech, I did talk to the society about the problem of overcriminalization, as I saw it. On the federal statutory books today, we have approximately 5,000 criminal laws. That doesn't count, of course, all the criminal laws at the state and local level. And Congress pours out a lot of new criminal laws all the time. Most of those laws are relatively recent vintage. And I asked my law clerks to go find out, okay, now, how many laws do we have that have criminal penalties that are in regulations too, right? Just out of curiosity. And I thought they'd be able to come back with a number. And apparently, they reported back, and I trust them, they're pretty smart. They came back and said that scholars have given up trying to count the number. They gave up at around 300,000. And Madison warned, you know, he lived in a time when there were too few written laws, so that the king could pretty much do as he or she wished. He, tyrannical king, that's the experience they had. But he foresaw a world and warned about a world in which we have too many laws, to the point where the people can't know what the law is. And of course, there's the great example of Caligula, right, who posted laws, ancient Roman emperor, deliberately posted laws written in a hand so small and up so high that nobody could tell what the law was. Better to keep the people on their toes. So, sorry. And that's a problem too, right? For due process, fair notice. And the truth is, and like so much else in life, we're aiming for the golden mean. Not too much, not too little. Point where people have enough fair notice, but aren't overwhelmed. That's what I spoke about.
Well, and I agree with you. It is a significant problem, one that this committee has addressed multiple times, and I hope will continue to address. Indeed, I'm reminded of one legal thinker who famously observed, "In heaven there is no law, and the lion lies down with the lamb. In hell, there is nothing but law, and due process is meticulously obeyed." And living in a situation where, by the count you just shared, there are over 300,000 potential crimes in a regulatory sense, at some point makes it exceedingly difficult for an honest citizen to conduct himself or herself in a way that doesn't run afoul of the law. And that is something that should concern all of us. You know, I would note, when you gave this speech, would you say it is fair to say that not everyone at the Federalist Society who heard your speech agreed with everything you said?
Oh, goodness. That was the whole point of the speech, Senator.
Well, and in my experience, a great many Federalist Society events are structured as debates, where you have sometimes sharply contrasting views for the purpose of intellectual discussion and hopefully thinking and addressing hard problems.
And there's a counterpart to the Federalist Society now, the American Constitutional Society.
Right.
One of my friends who's just here is on the board, does similar good work.
Sure.
I think these societies, debating societies, useful to ideas percolating and being shared in a civic way, in a way that we can discuss with one another calmly, coolly, thoughtfully, not yelling at one another, not using labels to dismiss one another. That's what I get out of them. I learn things.
I would note that the Federalist Society describes its purpose as, quote, "It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be." And I can think of very few people qualified to be a judge who would not agree with those basic precepts about the foundation of our country. Let me turn to a different topic, which is several of my colleagues on the Democratic side have focused on corporations and have been critical of decisions such as the Supreme Court decisions in Citizens United or Hobby Lobby, and have put forth the proposition that corporations are not people and hence cannot have First Amendment rights, cannot have free speech rights, cannot have religious liberty rights. And while that may be a perfectly fine debating point in a committee of the United States Senate, in a courtroom, it runs foursquare into decades, if not centuries, of precedents on the other side. The New York Times is a corporation. Judge Gorsuch, is there any credible argument that the New York Times enjoys no First Amendment protections whatsoever?
No, Senator.
The NAACP is a corporation. Is there any credible argument that the NAACP has no First Amendment protections?
I think these are long-settled precedents we're talking about.
And the same, I would note, is true for the NRA, for La Raza, for the ACLU. Every one of those is corporations, the Sierra Club, and every one of those the Supreme Court has for decades held. Simon & Schuster, a major book publisher. There is, every one of those the Supreme Court has held are protected by the First Amendment. Is that a fair characterization?
I believe it is.
I think that's important to note in the public debate, that part of the reason we have such a robust arena of free speech, part of the reason I think it is a good thing that on gun issues we have the NRA and the Brady Center debating back and forth, citizens of good intentions and morals believing strongly on an issue, expressing their First Amendment rights, petitioning Congress, speaking out publicly. And the First Amendment exists to protect your right on one side or the other to speak and let the public domain resolve that issue. Let me turn to a different issue and return perhaps to a lighter topic. I understand that you like to take your law clerks, some of them very much not from the West, to the Denver Rodeo every year, and to have them observe and react to cattle roping and bronc riding and mutton busting. Is that true? And can you share a bit of your experiences and even better theirs in that regard?
Well, Senator, I get law clerks from all over the country, many from my region. I maybe favor my region, but I get plenty from out of the area too. And we have a great rodeo in Denver every year, the Grand National. And it begins with a parade down 17th Street, which would be like a parade down Pennsylvania Avenue in D.C., where you have cattle. It's a cattle drive down the main road in Denver. They shut it down. That's how you mark the opening of the Grand National. And the closing of the Grand National is celebrated by the prize steer getting to spend a little time in the Brown Palace Hotel. Now, the Brown Palace Hotel is like the Willard, or pick your favorite fancy at the Plaza in New York. Yes, they bring the prize steer into the lobby of the Brown Palace. And in between, there's the rodeo and the stock show. And the kids show their animals. My kids never made it to the Grand National. They are more county fair types with their chickens and their rabbits and dogs and whatever. But the kids compete to the Grand National, this big time. And then there's mutton busting. And I think my children still have PTSD from mutton busting. Mutton busting, as you know, comes sort of like bronco busting for adults. You take a poor little kid, you find a sheep, and you attach the one to the other and see how long they can hold on. And, you know, it usually works fine when the sheep has got a lot of wool, and you tell them to hold on. I tell my kids, hold on monkey style, you know, really get in there, right? Get around it. Because if you sit upright, you go flying right off, right? So you want to get in. But the problem when you get in is that you're so locked in that you don't want to let go, right? And so then the poor clown has to come and knock you off the sheet. And my daughters, they got knocked around pretty good over the years.
Well, as a Texan, I think everyone's life could be rendered richer by going to the rodeo, and I thank you for sharing that experience with your clerks.
Oh, I'm sorry, all right. We could talk mutton busting all day.
Senator Franken.
Good to see you, Judge. Evidently, there's no animal abuse laws.
You sound like my daughters on that score, Senator.
I wanted to get to some questions, but first I want to talk about Trans Am trucking because Senator Durbin brought it up and Senator Lee brought it up. And I want to just go through the facts real quickly because I understand the reasoning behind your dissent, but I'm actually kind of puzzled by it as well. Okay, so Alphonse Madden's a truck driver. He's made a stop off the interstate at 11 p.m. He comes back on, or he's about to come back on, notices his brakes are frozen on his trailer. Okay, so he decides, I'm not going to go on. It's dangerous to go with frozen brakes onto the interstate, frozen brakes on my long trailer. He's in the cab, and he calls in pulls off the side, calls in for a repair. Gets to the dispatcher. Dispatcher says, well, wait, hang on there. We'll wait for it. Okay, a couple hours goes by. The heater is not working in his cab. It's 14 below zero. 14 below zero. He calls in and he says, my feet, I can't feel them. I can't feel my feet. My torso, I'm beginning not to be able to feel my torso. And they say, hang on, wait for us. Okay, now he actually falls asleep. And at 1:18 a.m., his cousin calls him and wakes him up. And his cousin says that he is slurring his speech and he doesn't make much sense. Now, Mayo Clinic in Minnesota says that is hypothermia. And he had fallen asleep. If you fall asleep waiting under 14 below zero weather, you can freeze to death. You can die. He calls him back, and the supervisor says, wait. You got to wait. So he has a couple choices here. Wait or take the trailer out with the frozen brakes onto the interstate. Now, when those brakes are locked and you're pulling that load on a trailer with its brakes locked, you can go maybe, 10, 15 miles an hour? Now, what's that like on an interstate? Say you're going 75 miles an hour. Someone's going 75 miles an hour. They come over a hill and slam into that trailer. Also, he's got hypothermia. He's a little woozy. Probably figures that's not too safe. I don't think you'd want to be on the road with him, would you, Judge?
Senator,
you would? Or not? It's a really easy yes or no. Would you like to be on the road with him?
Would I want to be on the road with him?
Yeah.
With the hitched trailer or the unhitched trailer, Senator?
Well, either, but especially with the hitched trailer with the locked brakes.
No, I don't think that was a serious
I thought that
option.
was,
agree
I
with
wouldn't
you.
want to be there either.
Yeah.
And
An
so what
unhitched
he
trailer.
does is he unhitches it
Right.
and goes off in the cab.
And then I believe he comes back 15 minutes later.
And he comes back after he gets warm so that he can be there when it gets repaired.
Right.
Okay, gets fired. He gets fired. And the rest of the judges all go, that's ridiculous. He shouldn't, you can't fire a guy for doing that. There were two safety issues here. One, the possibility of freezing to death or driving with that rig in a very, very dangerous way. Which would you have chosen? Which would you have done, Judge?
Oh, Senator, I don't know what I would have done if I were in his shoes, and I don't blame him at all for a moment for doing what he did do. I empathize with him entirely.
Okay, we've been talking about this case. You haven't decided what you would have done? You haven't thought about for a second what you would have done in
Senator,
his case?
I thought a lot about this case because
And what would you have done?
I totally empathize and understand.
I'm asking you a question. Please answer questions.
Senator, I don't know. I wasn't in the man's shoes, but I understand
You
why
don't
he
know
did.
what you would have done. Okay, I
understand.
tell you what I would have done. I would have done exactly what he did.
Yeah, I understand.
And I think everybody here would have done exactly what he did. And I think that's an easy answer. Frankly, I don't know why you had difficulty answering that. Okay, so you decide to write a thing in dissent. If you read your dissent, you don't say it was like sub-zero, you say it was cold out. The facts that you describe in your dissent are very minimal. But here's the law that, and you go to the language of the law, and you talk about that. I go to the law. A person may not discharge an employee who refuses to operate a vehicle because the employee has reasonable apprehension of serious injury to the employee or the public because of the vehicle's hazardous safety or security condition. That's the law. And you decided that they had the right to fire him, even though this law says you may not discharge an employee who refuses to operate a vehicle, because he did operate the vehicle. Was that right? That's how you decided, right?
That's the gist of it.
Well, no. Is that how you decided? That's what you decided,
Senator,
right?
there are a lot of more words in the opinions, both in the majority by my colleagues and in dissent, but that I'm happy to agree with you. That's the gist of it.
Right. Well, that's what you've said. And look, I'm not a lawyer, but I've been on this committee for about 8 years, and I've paid some attention. So I know that what you're talking about here is the plain meaning rule. Here's what the rule means. When the plain meaning of a statute is clear on its face, when its meaning is obvious, courts have no business looking beyond the meaning to the statute's purpose. And that's what you used, right?
That's what was argued to us by both sides, Senator.
But that's what you used.
Yeah, both sides
right.
argued
Okay.
that the plain meaning supported their
and
interpretation.
you used it to come to your conclusion.
Both sides.
But the plain meaning rule has an exception. When using the plain meaning rule would create an absurd result, courts should depart from the plain meaning. It is absurd to say this company is in its rights to fire him because he made the choice of possibly dying from freezing to death or causing other people to die possibly by driving an unsafe vehicle. That's absurd. Now, I had a career in identifying absurdity. And I know it when I see it. And it makes me, it makes me question your judgment. You stopped by my office a few weeks ago. I asked you about Merrick Garland. I had read somewhere that after you accept the nomination, it's been talked about, one of the first calls you placed was to Chief Judge Garland. And you said to me, I think the world of Merrick Garland. And I asked you a couple times if you were bothered by the way the Senate treated Merrick Garland, who you clearly have a great deal of respect for. You said something to the effect of, Senator, I try to stay away from politics. Now, you'd been on the bench for 10 years, so that sounded fair to me, and I decided to leave well enough alone. And I moved on to another topic. But your relationship with politics came up again yesterday. My good colleague, Senator Lee, lamented the extent to which the confirmation process has become political and suggested that you and other nominees are not equipped to navigate that process because confirmation politics are, in his words, quote, still a little foreign to you, are still quite unfamiliar to you. But it turns out that's not really entirely accurate. After you were nominated, this committee made a formal request for documents relating to your previous nomination and to your time at the Department of Justice. This is standard procedure. Those documents include emails back and forth between former Bush administration officials and you in 2004, back before you joined that administration. And the Neil Gorsuch in those emails seems to be very, very familiar with politics. The Neil Gorsuch in those emails was looking for a job. Here's a message you sent to Matt Schlapp, President Bush's political director. This was in November 2004, just after President Bush won re-election. Quote, "I spent some time in Ohio working on the election." This is you. "What a magnificent result for the country. For me personally, the experience was invigorating and a great deal of fun." Now, that doesn't sound like someone who steers clear of politics to me. You went on to write, quote, "While I've spent considerable time trying to help the cause on a volunteer basis in various roles, I concluded that I'd really like to be a full-time member of the team." You attach your resume, which describes in detail your work in support of political campaigns and candidates. Basically, you had worked on Republican political campaigns since 1976. You worked for Reagan, Bush 1, Bush 2. You were cited for distinguished service to the United States Senate for work in support of President Bush's judicial nominees by the Senate Republican Conference, which suggests that even the political aspects of confirming judicial nominees is something that you are not unfamiliar with. Now, when we met earlier, I asked you what you thought of the way Senate Republicans treated Merrick Garland, and rather than answer the question, you replied, "I try to avoid politics." But here you are in 2004, pledging your allegiance to the cause and shopping around a resume touting your work on political campaigns dating back to 1976. These messages establish that for a good deal of your prior career, you didn't avoid politics, quite the contrary. You were very politically active. So in light of that, I'd like to ask my question again. Do you think Merrick Garland was treated fairly by the United States Senate?
Senator, a couple of things in response to that, if I might. Going back, the absurdity doctrine argument was never presented to the court, and it usually applies in cases where there's a Scrivener's error, not when we just disagree with the policy of the statute. So I appreciate the opportunity to respond there.
When there is a Scribner there.
Scrivener's error.
Error.
Okay,
I'm sorry.
Not when we just disagree with the policy. With respect to campaigns,
well, if I read my statutory interpretation from, let's see, this is from the Notre Dame Law School, National Institute for Trial Advocacy. This is a pretty well-known exception to the plain meaning rule, and I think you can apply it without it. I mean, don't you think it's absurd that this man was given that choice and then fired for it? Don't you think that was absurd?
Senator, my heart goes out to him.
Okay, never mind.
My heart goes out to him. But it's just not my job to write that.
How do you think Merrick Garland was treated by the Republicans?
Senator, since I became a judge 10 years ago, I have a canon of ethics that precludes me from getting involved in any way, shape, or form in politics. There's a reason why judges don't clap at the State of the Union, and why I can't even attend a political caucus in my home state to register a vote in the equivalent of a primary.
Okay, but I don't think that this is you have to state your political views. That's not what this is about. How a Supreme Court justice who is nominated by the President of the United States, this is like in the Constitution. I think you're allowed to talk about what happened to the last guy who was nominated in your position. You're allowed to say something without about getting involved in politics. You can express an opinion on this.
Senator, I appreciate the invitation, but I know the other side has their views of this, and your side has your views of it. that by definition is politics.
Okay.
And senator judges have to stay outside of politics. I think the world of Merrick Garland. I think he's an outstanding judge.
Okay, I understand.
I've told you what I think.
I understand. Thank you. Thank you. I don't mean to cut you off, but, you know, we have time. I think it's really important for us to understand how your political work and your political views might inform the views of the law. And I know this. I don't hold it against you that you did political work. Lots of people did.
1976, I was walking the district with my mom.
Yeah.
When she was running for State House.
Looking again at the emails, 5 or so months after your message to Mr. Schlapp, you emailed Ken Mehlman. Mr. Mehlman was your law school roommate, and at the time you emailed him, he was chairman of the Republican National Committee. You just interviewed for a job at the Department of Justice, and you wanted him to put in a good word, so he did. Mr. Mehlman emailed the White House, and he wrote, Neil is a wonderful guy, was my law school roommate, did the 72-hour effort in Ohio for us, and was part of Lawyers for Bush. Mr. Mehlman wrote, quote, he is a true loyalist. Now, again, being politically active or a loyal Republican are not disqualifying characteristics for a Supreme Court nominee, not in my book anyway. But let's think back to the 2004 election. Let's look at Ohio, where you volunteered. Ohio is one of 11 states in 2004 where Republicans working to support the re-election campaign also worked to put anti-gay marriage amendments on the ballot. These state constitutional amendments passed, all 11 of them. The text varied state by state, but generally the amendments define marriage as being between a man and a woman. The amendments sent a clear message to lesbian and gay couples that their unions were not equal in the eyes of the law. Now, you were a campaign worker in Ohio. You'll remember the group Lawyers for Bush Cheney. As a lawyer and as a student of the Constitution, how did you feel about the right to marry being put to a popular vote?
Senator, I don't recall any involvement in that issue during that campaign. I remember going to Ohio.
Were you aware of that issue at all?
Oh, certainly I was aware of it.
And how did you feel about it?
Senator, my personal views, any revelation of my personal views about this matter would indicate to people how I might rule as a judge, mistakenly, but it might. Okay. And I have to be concerned about that.
These discriminatory amendments were part of a deliberative effort to drive up the turnout, and we know that because your friend Ken Mehlman said so. Mr. Mehlman was interviewed by The Atlantic in 2010 and said that the Bush campaign had, quote, been working with the Republicans to make sure that anti-gay initiatives and referenda would appear on November ballots in 2004 and 2006 to help Republicans. Now, to be clear, there's nothing to suggest that you were involved in crafting that strategy, but at the time, this tactic received a lot of attention, including in Ohio, where you worked on the campaign. There's a profound impact on people's lives. But a lot has changed. Since 2004, Mr. Mehlman announced publicly that he is gay, for one. He also voiced regret about what happened. He apologized. He said, at a personal level, I wish I had spoken out against the effort. As I've been involved in the fight for marriage equality, one of the things I've learned is how many people were harmed by the campaigns in which I was involved. I apologize to them and tell them I'm sorry. That's a brave thing to say. It's hard to admit regret. Mr. Mehlman had a personal connection to the issue, to be sure, but our country has come a long way in a relatively short amount of time. A lot of folks have changed their view about marriage equalities, Republicans and Democrat alike. In the meantime, the Supreme Court has settled this issue. Marriage equality is now the law of the land, so you shouldn't have any problem answering this question. How have your views of marriage equality changed, if at all, since the 2004 election?
Senator, my personal views, if I were to begin speaking about my personal views on this subject, which every American has views on, would send a misleading signal to the American people that my personal...
It's settled law.
It is absolutely settled law. There's ongoing litigation about its impact and its application right now. And I cannot begin to share my personal views without suggesting mistakenly to
Okay,
people.
can I move on to something else
Well, if
then?
I might
Thank
finish-
you.
if
I
I
understand.
finish-
You've given a version of this answer before, so I understand. I understand. I'd like to return to something I raised in my opening statement, and that's your view of administrative law. Standing before conservative activists gathered at CPAC, the Conservative Political Action Committee, President Trump's chief strategist, Steve Bannon, and his White House Chief of Staff, Reince Priebus, outlined the president's agenda. Two topics were featured prominently: deregulation and your nomination. Now, I don't think that's a coincidence. Reince Priebus started by explaining why nominating you was so important for the president to do right out of the gate. He said, referring to your nomination, quote, "Number one, we're not talking about a change over a 4-year period. We're talking about a change of potentially 40 years of law, number one." That's change of potentially 40 years of law. Change the law. You and your colleagues here have said the job of a judge is to follow the law, even if he dislikes the results. You've said that, not change the law or change 40 years of the law. But that's what Reince Priebus said this is about. When the White House Chief of Staff is talking to his friends at CPAC, he says that your job is to change 40 years of law. Yet my colleagues and you say it's to follow the laws as written. Well, it can't be both. So which is it?
Senator, it's to be a judge, to be fair, to follow the law, to apply it to the facts and circumstances of each case, and to live out my judicial oath on whichever court I serve on, whether it's the 10th Circuit, where I've served for the last 10 years.
Okay.
And where my opinions have been unanimous 97% of the time, Senator. I've been in
I understand, and again, you've given many times that answer, so if you'll indulge me. Mr. Priebus went on to say your nomination was central to President Trump fulfilling his policy objectives. Quote, Neil Gorsuch represents the type of judge that has the vision of Donald Trump, and it, referring to your nomination, fulfills the promise that he made to all of you, speaking to the conservative activists gathered at CPAC. What do you think that Mr. Priebus was talking about? Was he suggesting that if confirmed, you would be positioned to shape the court's decisions for the next 40 years, or was he suggesting you could reach back 40 years? Roe v. Wade turned 44 this year, and the president has promised to nominate judges who would overturn Roe. Chevron is 33 years old. I think this is a legitimate question. Was Mr. Priebus suggesting that you go back and change 40 years or of settled law or have an effect on the law moving forward?
Respectfully, Senator, Mr. Priebus doesn't speak for me, and I don't speak for him. I don't appreciate it when people characterize me, as I'm sure you don't appreciate it when people characterize you. I like to speak for myself. I am a judge. I am my own man.
Okay, I just want to we've had some talk about this. I don't think we're crazy to think that the administration and Reince Priebus, I don't think he was lying. And it doesn't are you comfortable with your nomination being described in such transactional terms?
Senator, there's a lot about this process I'm uncomfortable with. A lot. But I'm not God. No one asked me to fix it. I'm here as a witness, trying to faithfully answer your questions as best I can, consistent with the constraints I have as a sitting judge. Here to answer questions about my qualifications and my record.
I got it. Well, I find it unsettling that the administration is talking about, the chief of staff's talking about the Supreme Court that way. But I want to get back to the panel at CPAC. After Mr. Priebus discussed your nomination, Steve Bannon talked about the president's agenda. He described 3 priorities, and one of them was, quote, the deconstruction of the administrative state. Now, here's what Mr. Bannon meant by that. He said that regulation was a problem from his perspective. Quote, every business leader we've had in is saying not just taxes, but it is also regulation. He said that if you look at the president's appointees, quote, they were selected for a reason, and that is deconstruction. The way the progressive left runs is if they can't get it passed, they're just going to put in some sort of regulation in an agency. That's all going to be it's all gonna be deconstructed. Taking Steve Bannon at his word, do you think only cabinet appointees were selected to bring about this deconstruction? Or do you think the White House also sees a role here for its judicial nominees?
Senator, respectfully, I believe that's a question best directed to Mr. Bannon.
He's not here. I'm just quoting him, that's all. I think the White House does see judges as a part of this deconstruction. I think that they're seeing your nomination as an important step toward achieving this goal. You've shown a willingness to disregard agencies' interpretations of statutes. You did that in Trans Am trucking with the Department of Labor regulation, for example. You've done in other cases as well. And in August, you wrote that concurrence to your own unanimous opinion in which you described Chevron, the Supreme Court's landmark administrative law case, as, quote, permitting executive bureaucracies to swallow huge amounts of core judicial and legislative power. You wrote, quote, maybe the time has come to face the behemoth. Now, generally speaking, as we've discussed, Chevron provides the courts should defer to an agency's interpretation of the federal laws that it is tasked with administering. When Congress passes laws that require agencies to implement them, say by issuing safety standards for children's toys or rules that ensure that pharmaceuticals or medicines are safe, those agencies turn to experts to develop those policies. Experts like scientists at the FDA, for example. I think that's a good thing. We want experts doing the work. What we senators don't want to be doing is deciding how much lead can be in your water or what the distance in the slats are in a baby's crib. I don't trust Senator Coons to do that. Chevron provides that when agencies do that, courts should be wary of stepping in to overrule them without a good reason. This is Scalia's agrees with Chevron. But I'm concerned that this administration sees common sense health and safety rules as a burden on big business. And I'm concerned that they want to appoint pro-corporate judges who are willing to substitute their own judgment on these matters for those of experts. Do you believe that Chevron was wrongly decided?
Senator, I'm a circuit judge. I don't tell my bosses what to do. I do, when I see a problem, raise my hand and tell my bosses I see an issue here. And I did in that case, not because of any big corporate interest, but because of what happened to Mr. Gutierrez, an undocumented immigrant to this country, and the whipsaw that he was placed in by a change in law affected by an administrative agency, a bureaucracy, overruling a judicial precedent and telling him he now had to wait not 10 years out of the country, but 14, something like that. And, Senator, that's part of my job to say these things when I see problems like that. It's a due process problem I saw. And no one, Senator, is suggesting that scientists shouldn't get deference or chemists or biologists. Section 706 of the APA is quite clear that on facts, courts
you want to address this behemoth. And that suggests that the comments made by Mr. Priebus and Mr. Bannon know exactly what you think about these issues. And I think some of my colleagues on the other side of the aisle do as well. This is a big deal. During the entire 114th Congress, Chevron deference was mentioned only twice on the Senate floor, but between the announcement of your nomination on January 31st and last week, that decision was mentioned 30 times by 4 different senators. Each of those 4 senators discussed the case while speaking in support of your nomination. 3 of those senators are members of this committee. So I know you're choosing your words very carefully, and I know you're trying not to signal how you might rule in certain cases, but I think some of those signals have already been sent. Thank you.
Senator Sass.
Thank you, Mr. Chairman. Judge, you mentioned that there are a number of things about this that have been disappointing to you in the process. I'm disappointed in Senator Cruz, partly because he stole a lot of my originalism plan of questioning, but also because he went to mutton busting. I was convinced that I was the only guy that had mutton busting in today's pool. So my wife also sent me a text a little bit ago and said, and I'm sure she didn't expect me to read it, but how in the world is Gorsuch able to go so many hours at a time without peeing? I won't make you answer, but the SCOTUS bladder is something the whole country stands in awe of. So you're over halfway through your 11 hours today, so congratulations. Judge, let's do biography for just a second. You're a father. Remind me the ages of your children.
Boy, I don't even know what to say now. You really caught me off guard there, Senator Sass.
You're welcome.
My daughters are 17 and 15.
Okay. So besides fishing, have they ever played sports?
Oh, my goodness. Yes.
Have you ever gotten to a Little League game early, pulled the umpire aside in the parking lot, and asked him or her to commit in advance that they will decide the games for the underdog?
No, but I think some of my buddies have.
Have you ever asked a referee underneath the zebra stripes of their jersey to wear your kid's Little League jersey as the undershirt below
No,
the
it
referee's
wouldn't have helped any. My
umpire?
kids were pretty rotten at basketball.
We're obviously not going to pursue this very far, but I do want to make sure that everybody at home knows a little bit of what's been happening in the room over the course of the last 6 or 7 hours. Because some of my colleagues are asking a bunch of tough questions that are really important for you to have to answer. At the same time, there are a whole bunch of questions that have been asked today that are really asking you to take your legal career and your legal ethics and set them aside and play politician on TV today. And that really isn't your job, and some of this questioning really hasn't been a fruitful use of our time. It's well-meaning to talk about the outcome objectives of a whole bunch of these cases, but I would submit that it's dead wrong. I want to give you just a couple of the questions we've heard earlier today. At different times, how can we have confidence that you won't be for the big guy? At another point, how can we know that you feel for the little guy? This sounds noble, but it's fundamentally a corruption of what the judge's job is. To seek assurances from you like this is like seeking assurances from a referee before the game that they will pledge to a certain outcome before the tip-off. If the law is wrong, and I'm somebody who believes that lots of our laws are wrong and overreaching around here, the question should be directed back at us on this panel and on this dais why we don't fix the laws that are wrong. We shouldn't be asking you as the judge to commit that when our laws are clunky and bad and in conflict, you will divine how to change the law on the fly. That's not the oath that you'll take. That's not the Constitution that we've all taken an oath to and pledged to. And it's not what the American people want. So frankly, I applaud you for your perseverance and patience with us as we've continually gone down a path of asking you to answer questions, many of which are fundamentally political questions and that you shouldn't be answering and that we shouldn't be asking. So thank you for your endurance. I'd like to go back to something that's a little more productive for the committee and frankly, I think productive for the moms and dads at home. And I'd like to talk a little bit more about the judge's robe. We both spoke about it yesterday, I would note, with no coordination. It turns out we've both just read your stuff from the past. And the judge's black robe reminds us of the meaning of your job. It reminds the plaintiffs that stand before the court. It reminds the judge as he or she dresses in the morning, and it reminds our kids, or it gives us an opportunity to teach our kids. And you've spoken eloquently about it in the past, but I think it's fitting for you to unpack it a little bit more in light of some of today's questioning. Earlier today, you were implored to tell us a little bit more about what is in your heart. And I think that's fundamentally a confusing question for us to be asking of a judge, except insofar as we would ask you, are you a man of your word who, when you take an oath in your heart, are pledging to keep your word and to keep your oath? And I think we all know that the answer to that question is yes, and it's why you're going to be confirmed, because people believe you to be a good and fair-minded judge. But every American, in a more fundamental way, needs to know what's in the heart of legislators, because we are supposed to speak for the hearts and minds and hopes and dreams of 320 million American people. We are supposed to cast a vision for the country, those things we want to conserve and preserve, and those things that we should argue about and change. We are the ones who are supposed to weigh the pros and cons of various legislative options that are available to us. Judges, on the other hand, are supposed to be following the law impartially. Your heart is supposed to be inclined neither toward the rich, nor toward the poor, nor toward black, nor white, nor people with big bank balances or small bank balances, but your heart is supposed to be your commitment to the law as you find it. So let's engage in a little thought experiment. 30 or 40 years from now, when you retire and hang up your robe and you're out fishing or sitting on the front porch of your surely lovely home, and you look back over your career, how will you know if you were a good judge?
Senator, that's a question I ask my kids every semester when I teach ethics. Finish the semester with asking them to spend 5 minutes writing their obituary. They hate it. They think it's corny. I might be a little corny. And then I ask them if they'll volunteer to read some of them. And people want to be remembered for the kindnesses they showed other people, by and large. And what I point out to them, what I try to point out is, it's not how big your bank account balance is. Nobody ever puts that in their draft obituary, or that they billed the most hours, or that they won the most cases. It's how they treated other people along the way. And for me, it's the words I read yesterday from Increase Sumner's tombstone. And that means as a person, I'd like to be remembered as a good dad, a good husband, kind and mild in private life, dignified and firm in public life. And I have no illusions that I'll be remembered for very long. None. If Byron White is as nearly forgotten as he is now, as he said he would be, I have no illusions. I won't last 5 minutes. That's as it should be. The great joy in life, Shaw said, is devoting yourself to a cause you deem mighty before you're thrown on the scrap heap. An independent judiciary in this country, if I can carry that baton for as long as I can carry it, and I have no illusions I'm going to last as long as you suggest, and that'll be good enough for me.
Well said. And would it be that more who taught legal ethics and business ethics and medical ethics and theological ethics would assign their students the obituary challenge? We might live less in the soundbite culture and more in a way that thinks about service and duty and calling. It's a great assignment. Neither Cory Gardner nor Michael Bennet have to fear that you're going to challenge them for a Senate seat from Colorado in the future?
Senator, I admire them both, and I think it's a wonderful fact that they were both here to introduce me, and that they follow a tradition, the West, where Senator Salazar and Senator Allard, Republican, Democrat, introduced me last time around. And frankly, 10th Circuit nominations, thanks to, he's not here at the moment, but Senator Hatch cares about the 10th Circuit. Republican and Democrat generally go on very smoothly. And it shows. It shows that you all have picked, I don't know how it works. I don't know how this crazy process works. But the colleagues you've selected for me over the years are wonderful colleagues, wonderful people. And I've been richly blessed to spend 10 years with every one of them.
So when you distinguish between the rearview mirror of a justice later, or a judge later in life looking back, and the rearview mirror of a senator, we have different callings. And so I think, without putting words in your mouth, you're going to be able to say that you can be proud of your career even if you failed to advance your policy preferences in this calling. But unpack that for the American people. Help them understand how the retrospective look of a senator at her or his career is different than a judge's retrospective look?
I suspect, but I don't know because I haven't sat where you sit, and I wouldn't presume to be able to walk in your shoes. But I presume, gingerly, that you will look back on your career and say, I accomplished this piece of legislation or that piece of legislation, and changed the lives of the American people dramatically as a result. I was fortunate enough to serve as a page in this body many years ago. It's an experience every young person should have. It'll give them a lifelong love of this body. It is the greatest deliberative body in the world. I believe that even sitting here. A judge looking back, the most you can hope for is you've done fairness to each person who's come before you, decide their case on the facts and the law, and that you've just carried on the tradition of a neutral, impartial judiciary that each person can come to with some sense that they're going to receive a fair hearing for their disputes. That's what we do. We just resolve cases and controversies. And lawyers are supposed to be fierce advocates. And I was once a fierce advocate for my clients. But a judge is supposed to rule impartially, to listen courteously and rule impartially. So, frankly, my legacy should look and will look a lot smaller than yours. And that's the way the design of the Constitution works.
In an earlier line of questioning, you were asked about 2004 and the presidential election and your participation in it. I just want to clarify, you were not a judge in 2004.
Goodness, no.
Correct.
Senator. I was a private attorney.
And when you went onto the bench, what changed in your life?
Justice Jackson says, a robe changes a man, or it should. Now, I'm sure he would add woman today, too. A psychological change comes over that person. He was the fiercest possible advocate, attorney general for FDR. And he wrote a dissent, as we've talked about earlier, in Korematsu. He wrote the steel seizures concurrence. It's a brave man. That's a judge's judge. Calling it like he sees it in each case as it comes, and writing clearly so that people can understand exactly what he's up to. And he's not hiding behind jargon, legalese, or 4 million footnotes. That's the best I can do on that.
Senator Cruz earlier asked you a series of questions about originalism, and I appreciated your, I'll probably paraphrase you inartfully, but you said you worry that the labels sometimes put us into boxes that eliminate the requirement or reduce the requirement we have to actually engage each other's ideas. So I won't pin you down hard on the term originalism, but many have critiqued originalism, including in some statements yesterday and today here, as backward focused or, quote, too rigid in adapting to our changing culture. Do you believe that originalism is just one judicial philosophy among many, or is it a description of what judges do?
I'm with Justice Kagan on this. I think it's what we all want to know. I don't know a judge who wouldn't want to know what the original understanding is of a particular term in the Constitution or a statute. That's information that would be valuable to any judge and considered by any judge. Again, in Heller, for example, Second Amendment case, deeply thoughtful opinions by both sides on that question. It doesn't necessarily decide the case, but it provides us a language to talk to one another in which we're trying to seek something outside of ourselves, outside of our own personal beliefs about what the Constitution or the statute at hand means. We're trying to do it in a way that's neutral and that we can say provides fair notice to those whose lives we're affecting, so that we're interpreting the law in a way that we can say they should have known. They were on notice. We're not putting a person in prison willy-nilly based on our preferences or taking away their liberty, but we're preserving it in accordance with the Constitution as it was written.
I'd like to talk a little bit about cultural catechesis or civics. As you and I have discussed in previous meetings, I'm of a view that we have a crisis we are not passing on the meaning of America to the next generation. Something like 40% of Americans under age 35 tell pollsters that they think the First Amendment might be dangerous because you might use your freedom of speech to say something that would hurt somebody else's feelings. Actually, that's quite the point of America, right? That there are all sorts of things people might differ about, they might want to argue about. Our founders came here and they didn't have the same views of heaven and hell and how you achieve salvation. And they came together and they forged out of the many one polity where we have a shared framework for ordered liberty, where we protect each other's rights, even to be wrong about fundamental things, wrong in our own views as we wrestle with these things. But we debate big and important questions in Washington, but more fundamentally in Boulder or in Fremont or Omaha, Nebraska. And you do it in the town square, and you do it at the church or the synagogue, you do it in the bar. And you fight about questions, but fight free from violence. And so we protect each other's rights to argue and to dissent. And we're not explaining that First Amendment to the next generation. And I believe that all three branches, the legislative, executive, and judicial branches, are led by people who are taking an oath to a constitution that's about limited government. It's about principled pluralism. It's about intentionally distinguished and divided powers. And I think all three branches have an obligation to do some of that teaching about civics. President Reagan, long before he was Republican president, before he was a Republican governor, when he was a Democratic labor union organizer, Ronald Reagan used to say, in any republic, you're always only one generation away from the extinction of freedom. If we don't pass along the meaning of America to the next generation, it means the next generation of our rulers aren't going to understand why we have this beautiful inheritance that we have in a constitutional system of limits. As a judge on the 10th Circuit, and soon to be as a justice on the Supreme Court, can you explain what you think your responsibilities and freedoms are to teach civics to the American people?
Senator, as a judge on the 10th Circuit, I've tried hard to do that, literally teaching class, speaking where I'm invited, when I'm invited, going to law schools, talking to students who visit the courthouse. And it's been a great privilege and a joy. I think here of Justice O'Connor, Sandra Day O'Connor. And when she retired, she did an awful lot of this. She's done an amazing amount of work. And I do think that there is a need to remind people how to talk to one another, how we talk to one another, and more fundamentally about how brilliant the design of this Constitution is. Not perfect, but e pluribus unum, from anyone. And we are all, not Republican judges, Democrat judges, we're judges. And I think we do have an opportunity, and that's one of the things I look forward to as a justice. My little talks might be a little better attended on civics. And I hope to do that. Maybe that's a Western thing. I don't know, or Midwestern thing, Senator. But I really believe in this country, and I'm optimistic about its future. I see the young people, I teach them, I get law clerks. They really care about this country. And they give me hope every day. Senator Coons and I share the distinction of being Truman Scholars. And we go through the selection process of picking the next crop every year. Harry Truman didn't want a monument as a memorial here in Washington. Think about that. The humility of that. Instead, he wanted a living monument, a scholarship to young people who go on to do public service. Well, we've got two of them here. And every year when I go do that selection process, I don't know about Senator Coons, but it's one of the best days of the year for me, because I see young people full of enthusiasm for this country and anxious to make it better. I look forward to working, if I'm so fortunate to be confirmed, on just this topic, Senator, with you, with Senator Coons, and anyone else.
Talk a little bit about the role of writing in the life of a justice. Justice Scalia was obviously a writer with a flourish. You've discussed having been tapped in the past to participate in speech writing. Talk about the purposes of both concurring dissents and traditional dissents, and what you think the objectives are at the appellate level, in your opinions, and is there a distinction when you're on SCOTUS?
When I sit down to write an opinion, people sometimes ask me who I'm writing for. I'm writing for myself, trying to convince myself that I've got it right. And I go through a lot of drafts. And I sometimes, as my law clerks know, change tack as I'm drafting. I don't know how many drafts I've gone through on some opinions, but 30s, yeah, more.
He actually said 130, but whatever.
Because I'm trying to get it right. And I find I test ideas as I write. It's one thing to say to somebody else, oh, go write this up. It's another thing to have to sit down and write it yourself. And it exposes holes and gaps in your own thinking, causes you to question yourself, wonder whether you have it right. So for me, it's an exercise of getting it right and persuading myself at the end of the day. And writing in a language that persuades me. A lot of gobbledygook, and us lawyers are guilty of a lot of gobbledygook. That doesn't persuade me. I want to know through a clear line. I want to be able to see my argument from my topic sentences, and maybe it's Sister Rose Margaret, I don't know. But I want to see the argument flow. I want to see how it fits together, and then I want it torn apart by my law clerks who tell me I'm wrong. So it's an iterative process. So at the end of the day, that's what it's all about. And then it's about the test of my colleagues. And I take their comments very seriously. I believe in collegiality. I believe that 2 heads, 3 heads, 9 heads are better than 1. And so I think a good judge can't have too much pride of authorship as to accept criticism, constructive criticism, and try and incorporate or deal with that criticism. Maybe that's why my opinions have attracted relatively few dissents. I don't know. But I take collegiality very seriously. As to writing separate opinions, I don't do it very often. And when I do it, it's usually because I'm just stuck. I might be wrong, but I'm just stuck. Something doesn't seem right to me. And I've tried to discuss it with my colleagues. I've tried to work it out. I bend as far as I can bend. But at the end of the day, I take the oath to follow the law where it leads me. And I try hard to reach a collegial consensus, but when I can't, I write up what I can as respectfully as I can, and usually in as few words as I can, a dissent or a separate concurrence. Sometimes, because it's fact-bound, but it's just where I'm stuck. Sometimes because I see an issue that my bosses need to be aware of. Like any good employee, hey, boss, you might want to think about this one. Seems kind of tough to me. And I think that's part of the process of a good judge.
I'm a historian by background, and when I was writing my dissertation, to your audience question, one of my advisors just kept pounding me saying, I don't know who you're writing for here. It seems scattered all over the place. And he finally persuaded me to put a picture of my aunt on the farm next to my computer. And she's smarter than I am, but she knows nothing about my topic. And he said, if you recognize that your audience should be smarter than you, but ignorant of the subject matter, you're finally going to find your voice.
Yeah.
Is there something analogous in the writings of the Supreme Court where you're not just writing for other justices, but you have an obligation to write for the American people?
I think if you're sitting and writing your dissertation for yourself with your picture of your aunt, you're right on target, right? Because I think if I'm writing for myself and trying to persuade myself, then I figure everybody will be able to at least track what I did. Maybe not agree with every opinion, every single one of the 2,700 decisions I've issued, but they'll understand why I got where I got. I was candid about it. I didn't hide. I stood up. I was clear. I was honest. I was forthright, plain spoken. And you can judge my opinions, for better or worse, on their merits. And I think that's what a good judge does, is candor, the duty of candor.
We finished voting a day early last week, and so a lot of us were back in our states traveling and doing town halls and Rotary clubs and schools. I ran into 3 different teachers who planned to use these hearings on C-SPAN to teach civics. I wonder if you could help those teachers explain, as one of them asked me, about why we have a Bill of Rights. To remind the American people, the Constitution's a negative document. It is not the government giving us freedoms. It is us giving the government a limited set of enumerated powers. And originally there was no Bill of Rights. And as a part of a compromise, we added one. Today, most people, when they think about our Constitution, think of the Bill of Rights first. Why do we have a Bill of Rights, and what fundamental difference would it make if we didn't have one?
That's a big question for us adults.
Chairman said I could have an extra hour, so take your time.
Yeah, I've got 4 minutes and 19 seconds on that. That's a big question for us adults who are where we are. It's a big question for my middle school and high school age kids. The Constitution, as a negative document, the theory behind it, in short order, was to divide power, the better to protect liberty. That's the theory. That you put all power in one set of hands, you're going to get tyranny. And our founders had too much evidence of that in their own time. It's kind of a hard-won inheritance. Part Enlightenment theory, right? Part on the battlefield. They saw what it was like to have power amalgamated in one set of hands. Dangerous. So they divided it. They divided it 3 ways in our federal system. Write the laws. And it's tough. It's supposed to be tough to protect liberty. We don't just have one house, we have 2 houses. And then it has to be signed by the president, too. Really hard. Bicameralism and presentment is designed to make legislation difficult, the better to protect liberty. The president's powers are to execute the laws, not make them, not adjudicate disputes. Our role is to decide cases and controversies between the people under law as it is, not as we'd wish it to be. We're not legislators, we're judges. The legislative power is invested in this body. That's not all. Then we divide power in a way that was quite unique, well, unusual. Federalism. So you can think of separation of powers as having a horizontal access and a vertical access, so that the federal government has certain enumerated powers and authorities. And what the federal government doesn't enjoy, the states do, as sovereigns. This country as well, we have tribes, which also bear sovereignty in our part of the world and bear recognition as such. I'm glad to have the opportunity to recognize that fact here as a Westerner. So we have the separation of powers between horizontally and vertically. And that wasn't thought enough to protect liberty. The drafters of the Constitution, many of them thought that that would be more than sufficient, that that in fact was the main way to preserve liberty. But our founders were very suspicious and very jealous of their liberties. So they added the Bill of Rights, and they enumerated 10 of them, as you know, starting with the freedom of speech, freedom of religion, no establishment of religion, right to bear arms, the Third Amendment, which I'm glad we don't litigate much. I wonder how many of the high school kids now watching know what the Third Amendment's about. Go look it up.
And get $20 out of your pocket at the same time.
So that's what the Bill of Rights is about, is ensuring not just these negative protections, but some positive affirmative guarantees against governmental encroachment.
Thank you. I want to ask a few more questions about the Bill of Rights, but I'll save it for my next round since we're at 40 seconds remaining. Thank you, sir.
Thank you.
Thank you. Chairman Grassley, I'd like to ask unanimous consent to enter into the record a letter from 19 different faith-based and secular organizations expressing concerns about Judge Gorsuch's rulings on church and state and free exercise.
Without objection is centered.
Thank you. Good afternoon, Judge.
Aye, Senator. Good to see you.
It has been a very long and hopefully very informative and instructive day, and I'll suggest
Take this away from your time, but I want everybody to be aware that after you get done, Senator Coons, we're going to take a 10-minute break.
Thank you, Mr. Chairman. The Third Amendment, some would suggest, was rooted in the Delaware Constitution. So although obscure, it is still beloved by some in the first state. Let's have a conversation, if we could, about religious free exercise and about liberty interest. There's an enduring tension or contest in our history between individual liberty and religious free exercise and the ability of government to enact and enforce neutral laws. And I want to better understand how you view the proper balance between these competing core values. And to that end, I found Hobby Lobby and your contribution to it concerning and interesting. The case centrally involves access to health care coverage, including contraception, for about 13,000 employees across 500 stores of Hobby Lobby and the religious views of the owners of that corporation. And you, Judge, joined the 10th Circuit majority opinion, holding that this for-profit business could, because of the business's religious beliefs, refuse to provide its employees with access to family planning. But you went even further than the majority, writing an additional concurring opinion emphasizing that the owners of Hobby Lobby, the Green family, were entitled to personally raise their religious objections, notwithstanding that they operated the business through trusts and corporations. In coming to that conclusion, you opened your opinion by writing, and I quote, "All of us face the problem of complicity. All of us must answer for ourselves, whether and to what degree we are willing to be involved in the wrongdoing of others." Complicity is not a concept I've seen widely discussed in free exercise jurisprudence. Why did you choose to lead your opinion with this concept of complicity, and what's it mean as we're trying to assess free exercise rights?
So under the religious freedom, Senator, thank you. Interesting, good question. I mean, this is what it's all about. The Religious Freedom Restoration Act protects this exercise of sincerely held religious beliefs and affords them the highest protection known in American law, strict scrutiny. That's a law that this Congress passed because it wasn't satisfied with the degree of protection that the Supreme Court was affording the exercise of religious liberty under the First Amendment. Under Smith, this Congress found Smith, written by Justice Scalia, to be insufficiently protective of the right to free exercise.
If you could, Judge, help me with your choice of the term complicity, which doesn't appear in that statute and hadn't previously appeared in free exercise jurisprudence.
Thank you for prodding me along. The point is, what's a sincerely held religious belief? The individuals there were devout Christians, and as they interpreted their religion, it was a violation, a sin, for them to participate in any way, in signing papers even, to allow the provision of certain contraceptive devices, those that they believed had the effect of destroying a fertilized egg.
Right. And
They were
that's
okay.
exactly, excuse me, Judge, but that's exactly why the question of your use of this term complicity is so interesting to me, is that it opens up a very broad, very attenuated, very remote connection between sincerely held religious beliefs by this devout family through a trust, through a corporation, a for-profit corporation, to impact the choices and life decisions of 13,000 people. It's a truly unprecedented decision. If I could just quote for a moment what I suspect is familiar to you, the dissent of the Chief Judge in your circuit, Briscoe. She said this opinion was nothing short of a radical revision of First Amendment law, as well as the law of corporations, wholly unsupported by the language of the Free Exercise Clause or the Supreme Court's previous free exercise jurisprudence. She claimed, Judge Briscoe, that there was literally no support for the proposition that for-profit corporations enjoy free exercise rights in the Supreme Court's previous jurisprudence. And I'm struck by the extent to which the use of the term complicity and your description of a substantial burden on a sincerely held religious belief opens possibly floodgates for litigation on behalf of those who have sincerely held religious beliefs. As you mentioned, the issue here was access to family planning. There were more than 20 forms of contraception that could potentially be covered. There were only a handful, I think 4, that the Greens objected to.
Right.
How far does this new concept, this newly injected concept of complicity go?
Senator, it's not a new concept at all, with respect, because in enacting RFRA, Congress revived some older free exercise case law.
That's right.
Much of it written by Justice Brennan. Thomas would be a leading example, involving, I believe it was a Jehovah's Witness.
Yes.
Okay. Who was okay in producing certain goods that could be used as armaments, but not others.
Right.
Complicity in war making was a matter of faith to
The key distinction, if I could, Your Honor, between Thomas and this was that in that case, here's an individual who's deeply held religious belief, made him say, I can't make turrets for tanks.
Right.
So the question is uniformly applicable law, unemployment insurance, can he benefit? Fine. But it doesn't in any way implicate others' liberty interests. The core concern with the choice to recognize a very large, multi-billion-dollar nationwide for-profit company and to privilege the religious interests of its owners through the legal fiction of a for-profit corporation is it impacts 13,000 individuals. That wasn't the case in Thomas.
Senator, respectfully, I think we're mixing apples and oranges, because the first consideration is whether we have a substantial burden on a sincerely held religious belief.
Mm-hmm.
The second is whether the government has a compelling interest narrowly tailored to override it.
Right.
And I think we're mixing apples and oranges, because on the first one, complicity is very much in play, and it's the same in Thomas as it is with the Greens. How far does my religious faith, your religious faith, permit us to engage in things that our religion teaches are wrong, sinful? That's a matter of religious faith. And in fact, I don't recall anyone doubting or the government disputing that the Greens' religious faith was sincerely held on
That's
this
right.
score. So I think it's a given. So this complicity discussion, I think, frankly, Senator, is a red herring to mix my metaphors, because everyone accepted it.
We've got apples, oranges, and red herrings.
I know I'm
Have a
mixing
full meal,
I
please.
know it's terrible. I wouldn't want to write it down in an opinion. It's terrible.
Well, let me
but-
take, if I could, let me take you to a number of things, because several other senators have referenced Hobby Lobby. One of the things that Judge Briscoe was saying was sort of category shattering or precedent setting was the extension to a for-profit corporation. The recognition of a for-profit corporation that sells crafts and hobby materials as being a religious corporation. Previously, only incorporated churches or synagogues or associations explicitly nonprofit religiously affiliated organizations have been recognized. In the interpretation of RFRA, you choose to define person to include for-profit corporations. Help me with why you made that move.
Be delighted to, Senator, and thank you for the opportunity. I think I'd point to a couple of things. First, RFRA is a statute, and it uses the term person, and it doesn't define the term person. And when Congress doesn't offer us a specific definition, we go to the Dictionary Act, which Congress has passed for just these circumstances. And there it says persons include corporations. That's the law, as Congress wrote it. And if Congress wishes to change the law and say only natural persons enjoy the rights of RFRA, I'm a judge. I follow the law. But the law, as drafted, doesn't distinguish between natural persons and corporations. It includes them both. And the government, Senator, if I might just finish, conceded, as I recall, and my recollection may or may not be great on this, but as I recall, conceded that nonprofit corporations can exercise religion.
That's right. And that's exactly why this was seen as such a departure. There was a long-settled expectation that religious free exercise rights adhered to individuals, living, breathing people, and to nonprofit corporations. It was a big leap for it to, for the first time, apply to for-profit corporations. And I appreciate that the opinion of the majority and your concurrence referenced the Dictionary Act. But the Dictionary Act actually says, on its own terms, that it applies unless the context indicates otherwise.
Right.
And the reality is, as I think one of the dissents points out, all Congress was intending to do, as expressed by a number of members of Congress, was to simply restore strict scrutiny. not to open up a whole new line of free exercise rights for-profit corporations. So I think the context clearly indicated otherwise. And to simply say, all I did was pull a dictionary off the shelf, look it up, person can include corporations, we're done with the analysis, is in some ways tendentious, because the idea that a for-profit corporation could have religious free exercise rights was nowhere in the earlier case law that Congress explicitly intended to be the narrow purpose of RFRA. So does Congress's intent when it passes a statute, its clearly stated intent, have any relevance to your interpretation, especially where something like the Dictionary Act actually urges you to look at the context?
Senator, I'll offer you two thoughts on that. First, as I recall, sitting here, and I have to go study my books, but the Supreme Court in an earlier First Amendment case did recognize a challenge by an Orthodox Jewish shopkeeper to Sunday closing laws.
That's right.
That was a corporation, for profit. So respectfully, I'm not sure it's accurate to say there's no precedent for it. Second, I would say to you, the position you're advocating is a fine position, respectable position. It's a good position. It was adopted by precisely 2 justices of the Supreme Court, and only 2.
So the question I want to ask you now is, at what point, given this newly adopted, fairly broad interpretive standard, when do we stop deferring to an employer's religious beliefs when they conflict with generally applicable laws of neutral meaning? When do we allow the right of one to implicate the others? I think it was Justice Holmes who was attributed to have said that your right to swing your arm stops at the end of my nose. And part of what I think made Hobby Lobby striking to so many was that the choices of 13,000 individuals about their method of family planning were overridden by the sincerely held religious beliefs of a very successful family. So I'm looking for how you find a limiting principle in this new field. What's the limiting principle now?
Senator, respectfully, I don't believe that's accurate either, because all the court held was that the government had to come up with another alternative to provide the contraceptive care it wished to provide. The court acknowledged, the Supreme Court acknowledged that there was a compelling interest in providing the contraceptive care, and simply said that an accommodation could be reached that didn't involve the Greens or require them to give up their sincerely held religious belief, much as had been done for churches
That's right.
and hospitals and lots of other entities. And the government couldn't explain why it couldn't accommodate other entities like Hobby Lobby
That's
as
right.
well, or Little Sisters of the Poor.
But if I might just briefly, Judge, strikingly to me, in the 10th Circuit opinion in which you participated, you didn't recognize as a compelling interest gender equity in providing health insurance to millions. The Supreme Court did. They balanced these equities differently. Why didn't you think that that was a compelling interest to provide access to health care for millions?
Senator, I think it was just a matter of what the record was in that particular case before us.
That's also a striking point for me. This was a preliminary injunction. It's a significant, groundbreaking opinion where one of your colleagues, one of the other 10th Circuit judges, said we really shouldn't be deciding something of this import on a PI. We ought to be remanding to develop the facts below. The facts weren't really well explored. And the larger point I'm trying to make is that I think this could lead to some very troubling applications. So let's just take a minute and look at a few of the contours of what this, I think, precedent-setting decision might mean. So let's imagine the Greens were from a different religious perspective. If they were Scientologists, for example, who reject the use of antidepressants, or Jehovah's Witnesses who reject the use of blood transfusions, or Christian Scientists who reject really modern medicine largely altogether, could their sincerely held religious beliefs as Scientologists or Jehovah's Witnesses or Christian Scientists lead to the conclusion that 13,000 employees could reasonably be denied access to antidepressants or to blood transfusions or to health care whatsoever?
No, Senator, not necessarily. It doesn't mean that at all. All it means is that the government, under the law as passed by this Congress, with overwhelming bipartisan support at the time.
Well, the ACA was not passed with overwhelming bipartisan support.
I'm sorry, I'm speaking of RFRA.
Right. The accommodation is in the ACA.
Oh, and the ACA, you can override RFRA anytime you want. Congress could say RFRA doesn't apply to the ACA. That's another alternative. You can abandon RFRA. You can say it doesn't apply to this particular statute. You can say it applies only to natural persons. You can say it doesn't apply to contraceptive care. Congress controls this decision, Senator.
That's right.
It's your decision. It's not mine, with all respect. We're just trying to implement what you've asked us to do.
So-
and Senator, on your hypotheticals,
Yes.
okay, Justice Brennan wrote these First Amendment cases that you were seeking to revive. I'd remind you of that.
Yeah.
All right? Justice Brennan. All right? And the fact of the matter is, sometimes the government can prove a compelling interest and that it's got the most narrowly tailored way to get there. And sometimes it can't. And each case has to be taken on its facts in the particular context in which it arises.
Well, then help me walk through, if you would, given we already know how you draw the compelling interest line in this particular instance of access to family planning or contraception. How else might you weigh these equities or draw these lines? If the Greens, for example, in Hobby Lobby, knew that several of their employees would spend their paychecks on other things they might say were immoral, like gambling or prostitution, could they refuse to endorse their paychecks?
Senator, it would go back to, we do the analysis,
Right.
the same analysis. Do they have a sincerely held religious belief? Sometimes people don't. I've had claims, for example, of individuals.
But in this instance, wouldn't you agree that their sense of the complicity that you referenced in your opinion would likely apply?
It depends.
Even though it's very attenuated.
Oh, no,
The choice of their employee to spend their money in a way they disapprove, isn't that different from the choice of the employee to choose among 24 forms of contraception, one of which they strongly disapprove?
Senator, I think it depends on the facts of the case. So, for example, I've had a case where a number of people came before us and said, we have a sincerely held religious belief that marijuana is God. Okay? It turned out it was a drug distribution ring,
Right.
all right? And what they really worshiped was the almighty dollar.
Many of us have teenagers at home watching.
Right, and they were really just trying to make a buck, okay? And the district court found that that wasn't a sincerely held religious belief. So that you can get off the train there. That's one place where you may get off the train in your hypothetical. You got another place you can get off the train. Is it a substantial burden?
Right.
Another place is compelling interest by the government. Another place is narrowly tailoring. So there are 4 steps in the process, and you have to go through all 4 of them as a good judge with the facts of each case as it comes. And Senator, again, it's all statutory. You could abolish it tomorrow.
Well, let's take an example that I think was central to a lot of this analysis, United States versus Lee. It's an older case, 1982. It was a unanimous case. It's one where an Amish businessman declines to pay for Social Security taxes,
Right.
Not just for himself, but for a few of his employees. And the court rejected his claim because the restriction on religious freedom, in their view, unanimously, was essential to accomplish an overriding governmental interest. Is Lee still good law?
I think Lee would be the sort of law you look at when you're applying RFRA, absolutely.
Because RFRA simply restored the
Yes.
strict scrutiny standard that Lee was decided under.
The Religious Freedom Restoration Act, exactly. So that's a very good example, Senator, of where the government was able to prove compelling interest in narrow tailoring. Yes.
Because the ability to have a Social Security scheme nationally that is sustainable is a compelling interest,
Yes.
but a nationwide plan to provide access to health care isn't.
No, Senator. Again, I think we're mixing our apples and our oranges because the government in the ACA was spotted the compelling interest. The problem was the narrow tailoring. You could get there without forcing the Greens to do something their religion prohibited. So it wasn't like the system of Social Security, which depends upon everyone's participation. That was a distinction the Supreme Court drew.
Let me just quote, if I could, Justice Scalia, who addressed this same issue in Employment Division v.
Yeah.
Smith, and who said, it's precisely because we're a cosmopolitan nation made up of people of every conceivable religious preference, and precisely because we value religious divergence, that we cannot afford the luxury of deeming presumptively invalid, as applied to the religious objector, every regulation of conduct that doesn't protect an interest of the highest order. Now, obviously, the law's changed in terms of the review standard, but do we, because of Hobby Lobby, now have to deem every law to be presumptively invalid if it offends any conceivable religious preference?
Under the Religious Freedom Restoration Act, it's a 4-part test, effectively.
Right.
all right? And for every challenge, you ask those questions. Is there a sincerely held religious belief? Is there a substantial burden on it? If check, then you go to the government side of the ledger. Do they have a compelling interest? And is it narrowly tailored? And that's the law you've set forth, Senator, because this body didn't like, frankly, Justice Scalia's decision in Smith. And if this court, if this, the old trial lawyer in me, sorry, getting tired. If this Congress wishes to say Justice Scalia was right in Smith and we've changed our minds, that's entirely up to this Congress.
Well, I'm going to move on to another line of questioning, but I just want to say that one of the challenges I face in a couple of different gates through the analysis as laid out was how you decided to interpret the underlying RFRA statute, how it was extended to for-profit corporations, how the balance was struck between what I think are the mediating decisions of thousands of individuals versus the free exercise of the Greens. You've talked about being a Westerner. You've, I think, entertained us with mutton busting, something I haven't seen yet, and clearly I should. And I'm interested.
I recommend it.
I'm interested in your view of privacy and the autonomy of adults to make their decisions. It was, in fact, I think, Justice Scalia who said there isn't a genuine Westerner on the court and that California doesn't count. As I shared with you, some of my extended family was from the West, and I think of Westerners as steadfastly independent folks. Justice Douglas, a famously Western justice, once said, "The right to be let alone is the beginning of all freedom." So in 2006, you authored a book, The Future of Assisted Suicide and Euthanasia, a topic of intense personal interest to many. And when reviewing your book, I was expecting you to conclude that people have the right to be let alone, because I think of that as an inherently Western trait, to make important and difficult personal decisions without the interference of government, but you didn't. Instead, you expressed a belief in the inviolability of human life. What did you mean by that?
Senator, respectfully, I'm not sure I'd agree with your characterization.
Of the book or of being a Westerner?
Of the book. I agree with your characterization of being a Westerner. The book does conclude that Cruzan is absolutely correct, that there is a right to be left alone at the end of life. These are hard decisions. I don't pretend to have any perfect answers here. I was writing this book, it's my dissertation, trying to contribute to what I thought was a very hard question. I still think a very hard question, one we all have had personal struggles with, Senator, as I know you have and I have. And this is a human problem. We're mortal. Cruzan held that people have a right to be left alone, presumptively, under the common law, presumptively constitutionally, to stop care, go home, die in your own bed, as a lot of my family members have done. The question is whether you should also have an additional right to have someone kill you, involve doctors in killing. And there are good arguments on both sides of that ledger, as I explore in the book.
Well, if I can, Judge, I'd like to help walk through that exploration of what you looked at in the book. And I think the Cruzan decision is a very important one. Because essentially the tension here is between whether there's a right for a conscious terminally ill adult to end their own life by refusing life-saving hydration and nutrition, as the Supreme Court assumed in Cruzan, or with the help of a doctor. And a lot of this rests in whether there is a right to privacy. Do you believe the Constitution contains a right to privacy?
Yes, Senator, I do. Privacy is in a variety of places in the Constitution. The first and most obvious place, back to the Bill of Rights, is the Fourth Amendment, right? The right to be free from unreasonable searches and seizures in your homes, papers, and effects. That's privacy, right? The Third Amendment, which I alluded to but didn't want to reveal.
Quartering of troops in home.
No quartering of troops. Stay out of my house with your troops. Now, happily, we don't litigate that much, right? The First Amendment, right? The right to free expression, which we've been talking about, and the freedom of religious belief, expression. That requires a place, privacy. And the 14th Amendment, Senator, over now about 80 or 90 years, the Supreme Court of the United States has held that the liberty prong of the Due Process Clause protects privacy in a variety of ways, having to do with child rearing and family decisions, going back to Myers, which involved parents who wished to have the freedom to teach their children German at a time it was unpopular in this country, and Pierce, the right of parents to send their children to a parochial school if they wish. So, Senator, yes, the Constitution definitely contains privacy rights.
One of the things that you say in your book, unequivocally, is that, and I think I quote, all human beings are intrinsically valuable, and the intentional taking of human life by private persons is always wrong. And I think that's a dividing line you draw between the facts in Cruzan and what has been proposed or adopted in states like Oregon. Can you point to any principle of constitutional law that says that, or has that principle, as you enunciated it, ever been offered by the Supreme Court or recognized by the Supreme Court?
Senator, I was speaking as a commentator before I became a judge, not expressing views as a judge, all right? My views as a commentator I'm happy to talk about, though. I found this a very difficult question. The Supreme Court has held that this is an issue for the states to decide under Glucksberg and Quill, for the people to decide on the state level. I agree with those decisions. I say so in the book. My concern about legalization that I express in the book as a commentator has to do with the equal protection principles we've been talking about today, the equal justice under law principles. And I am concerned, in the book, I express concerns as a commentator about what legalization might mean for the least amongst us, the most vulnerable, the disabled, the elderly, who might be pressured into accepting an early death because it's a cheaper option than more expensive hospice care, things like that that might cost more. And so that was a concern I expressed. Senator, I don't pretend, though, to have the last word on that or to know the right answer. I was contributing as a commentator to what I thought was a very hard discussion.
It is a very, very hard discussion, as you said, something that has an enormous impact on the terminally ill and their families.
Yes.
There was a case that I think was active at the time you were at the Department of Justice, where the U.S. Attorney General was suing Oregon to block their death with dignity law that permits, in that state, physician-assisted suicide. And in the documents you produced to this committee, you sent a message expressing hope that the federal government would win that particular case. Why did you want the federal government to win that case?
Well, I was an advocate for the government at the time, Senator. That's my job, all right? When you represent the government, you want the government to win. When you represent somebody against the government, you want the government to lose. And as a judge, Senator, it's a very different mindset.
And when you're up for consideration for the Supreme Court, it's important to know what you view as settled precedent. So let me, in my last 2 minutes, ask a question or two about that. In the Glucksberg case, which is about physician-assisted suicide, Justice Stevens said in his concurrence that avoiding intolerable pain and indignity of living one's final days incapacitated and in agony is certainly at the heart of the liberty to find one's own concept of existence, citing the Casey decision. What's your view of the application of Casey's mystery of human life language here?
Senator, the Supreme Court in Glucksberg, the majority held that this issue is for the states to decide and the people to decide. People of Oregon have made their decision to legalize it, for example. It was just legalized in November in my home state of Colorado. That's their right.
And how did you feel about that?
Senator, my personal views have nothing to do with my job as a judge.
Let me ask one last question, if I might. There was a line in your book that reminded me a great deal of Justice Scalia. You said that a libertarian principle legalizing physician-assisted suicide would require the government, inevitably, to allow sadomasochist killings, mass suicide pacts, duels, the sale of one's own life, not to mention illicit drugs, prostitution, the sale of one's organs. Help me understand, in closing, why finding a constitutional right to physician-assisted suicide would directly yield to this long list of other, perhaps more shocking, constitutional rights to prostitution or drug use or the sale of organs. Help me understand that leap.
Senator, in each chapter, I analyzed different potential arguments, one of which was this libertarian argument. And applied faithfully to its end, it leads to where it leads, as some of the authors of the argument acknowledge. I'm not making it up. There are other arguments, though, that one might deploy that I analyze as well. That's not the only available argument for legalization by any means.
Thank you, Judge. Thank you, Mr. Chairman.
We'll recess for 10 minutes, so that'd be approximately 5:40. And then it'll be Senator Flake.
As Chairman Grassley leaves the room, we'll remind you it's a 10-minute break, and he's been sticking pretty close to the time limit. When they come back, there are 6 senators that have yet to ask questions. On the Republican side, Jeff Flake will be next. Still to ask questions, the Republican side, Senator Mike Crapo, Tom Tillis, and John Kennedy of Louisiana. On the Democratic side, Richard Blumenthal of Connecticut and Mazie Hirono of Hawaii. That means at least another 3 hours of questions, each senator getting a half hour on this second day of the confirmation hearing for Judge Neil Gorsuch to the Supreme Court. They will continue tomorrow with more questions for Judge Gorsuch, getting underway at 9:30 Eastern, as will our live coverage here on C-SPAN 3. On Thursday, they're expected to wrap up the hearing with testimony from those favoring and opposing the nominee. Of course, we will have live coverage when they gavel back in, but we wanted to take you back to earlier in the meeting when Senator Leahy, the former chairman of the committee, asked Judge Gorsuch about people entering the U.S. because of their religion and asked about the president's recent issuance of a travel ban. Here's what he had to say.
I hear stories from my grandparents when signs used to say no Irish need apply, right, or no Catholic need apply. I'm sure Senator Feinstein could speak about those of her religion. Now, President Trump promised a Muslim ban. He still has on his website to this day, he's called for a total and complete shutdown of Muslims entering the United States. And a Republican congressman recently said the best thing the president could do for his Muslim ban is to make sure he has Gorsuch on the Supreme Court before the appeals get to that point.
Senator, a lot of people say a lot of silly things.
Oh, that sounds silly.
My grandfather...
That's more than silly. That's say this congressman wants you on the court so they can uphold a Muslim ban.
Senator, he has no idea how I'd rule in that case. And Senator, I'm not going to say anything here that would give anybody any idea how I'd rule in any case like that could come before the Supreme Court or my court or the 10th Circuit. It would be grossly improper of a judge to do that. It would be a violation of the separation of powers and judicial independence if someone sitting at this table, in order to get confirmed, had to make promises or commitments about how they'd rule in a case that's currently pending and likely to make.
And now the Grassley.
So far, I think you can see that this nominee is very well qualified. I think he is taking on almost every question and answering it very thoroughly and within the Ginsburg standard, delivering answers as best you can when there's prospective cases coming before you. And I think that besides being well qualified, he has demonstrated very good knowledge of not only the cases he's been involved in, but cases throughout our constitutional history. So he's done very well. I expect that we'll have a full day tomorrow, 20 minutes each, and that we will be able to get done tomorrow with him and then proceed Thursday, as you know, we have planned with other people to testify. So I'll take any questions you have.
Is tomorrow a full day of questioning, you think? Can you give us a sense tomorrow?
I don't think it would go late into the evening like it will tonight, because there'll be 20-minute rounds, and I think people will be satisfied. But I can't predict, but I do know this. So we're going to get done tomorrow, even if I don't get to bed at 9 o'clock.
There were several areas where there seemed to be discrepancies between promises the White House has made about how the judge would rule on issues like abortion or being part of, quote, deconstructing the administrative state, where the judge said that he didn't subscribe to those positions or hadn't been asked about them. Who do you think the public or senators should believe about what will happen? Should the people believe the assurances of the White House, or should they believe Judge Gorsuch?
I think you should believe Judge Gorsuch for this reason. I remember one time, and I won't say who the president was, I won't say who the nominee is, but I asked a president one time when there was a Republican nominee up if they asked the question about abortion, and that president was offended that I would even ask the question. So I think that you have enough practice, but I think this person has demonstrated his integrity over a long period of time, that his adherence to the law and to the principle of independence, that he would be saying it the way it really is. And besides, we don't have any evidence from the other end that those questions were ever asked. And he was there, we weren't there. So I don't know what else you can do unless you want to ask the president himself.
Do you think any of those statements by the president or by Reince Priebus, Steve Bannon, suggesting that Judge Gorsuch needs to be confirmed in order to overturn Roe versus Wade or accomplish some other policy objective, like the travel ban, do those create challenges for you guys in getting and advancing?
Not at all. I think that's all political propaganda that you'd expect out of people that work for a political being, and the White House is pretty political, isn't it?
On a different matter, yesterday there was another hearing, as I'm sure you're aware, in House Intelligence, in which the FBI director stated that there was no wiretapping by President Obama of Trump Tower. Does President Trump need to withdraw that claim at this point and apologize to President Obama?
I think I'll leave that up to the President of the United States, but I think another thing that was done that a lot of people, I don't know whether it's any of you or not, but a lot of people in your profession were reporting that Comey said that the president was under investigation. Comey didn't say that. He said people in the Trump campaign were under investigation. And I don't know how it gets reported that the president's under investigation.
Senator Grassley, what's your reaction to Senator Schumer saying the proceedings for Neil Gorsuch should be delayed because of the FBI
investigation into the Trump administration and their contacts with Russia?
I think that it's ridiculous, first of all, and second, there is a process for determining whether or not the president should be in office, but as long as he's in office, he can exercise these constitutional powers, and that's what's being done here. But I think it's ridiculous to think when a president that's duly elected should stop functioning as president of the United States. That's simply ridiculous, and that's really what Schumer would be asking the president to do. He's got the power to nominate. We have the power to confirm or not make any decision at all. And the president has performed his constitutional responsibilities, and we would expect him to, because he took an oath to uphold the Constitution.
Senator, your 10 minutes are up.
Okay.
Thank you, Senator.
Can you believe that? I got to stand by my own rules.
Well, perhaps reminded of his time constraints, Chuck Grassley, the chairman of the Judiciary Committee, wrapping up his brief comments with reporters outside of Hart 216, the room where the hearing is being held this week. This is near the end of day 2, but there's still 3 more hours or so of questions. There are 6 senators who have yet to ask their first round, that half-hour round, and you heard Senator Grassley talk about tomorrow with 20-minute rounds for questions tomorrow. That should be it in terms of questions, direct questions for Judge Gorsuch. Thursday's plan is for testimony of witnesses supporting and opposing the nominee. We'll want to remind you of a couple of times. Tomorrow at 9:30 is when we'll start our live coverage, and all of today's proceedings will re-air tonight, as of now, over on C-SPAN 2, beginning at 8 o'clock Eastern.
You need help with that?
Before,
I'm sorry.
before I call on Senator Flake, this is how I would like to go forth for the rest of the evening. We have a vote scheduled at 6:10. That'll be about the time that Senator Flake will be finishing. I would like to have Senator Blumenthal would be the next one up. I would hope, Senator Blumenthal, you could go vote at 6:10 and be back here and take over, and I'll operate within that. And then I would like to suggest that I have asked Senator Tillis to take over about 8 o'clock, so I can be in bed by 9 o'clock, because I get up at 4 in the morning and I want to be able to get a good night's sleep so I can run in the morning. And so you understand, Judge, that I'm not. I hope you'll understand why Tillis has taken over.
A little envious,
okay,
Mr. Chairman.
Senator Flake.
Thank you, Mr. Chairman. Thank you. This is a long day, and I know what it feels like. It reminds me of mean at the end of the table, I have 10 brothers and sisters, and getting there, and there's no more questions to ask. No more food left on the table either. But I appreciate your endurance here. And speaking of I have 10 siblings. I have 5 children as well. I don't know about my colleagues, but that's how I get elected in Arizona. But it helps. Not so much for a judge, but for senators it does. And just like Ben's family, my family's been texting me throughout this process, asking me to ask questions that they would ask. I asked a few of them, for suggestions, and my son Dallin, a teenager, said, ask him if he would rather fight 100 duck-sized horses or 1 horse-sized duck. I'd never heard it either. Apparently it was a question on Reddit a while ago, but anyway, that's where it's going from here, I think.
You can tell him I'm very rarely at a loss for words.
Okay, all right.
But you got me.
I will tell him. A teenager stumped you there. My brother Scott asked if you've ever worn gym shorts and a tank top under your robe.
Senator, on that one, we have what's called the Fifth Amendment, which is part of the Bill of Rights as well, and which, of course, protects the right not to self-incriminate. So I might have to exercise my rights under the Fifth Amendment to that one.
That is a good answer. My mother asked a little more serious question, and this goes to how you spend your time to let people know more about you. How do you like to get your hands dirty? We like to ski, but that's kind of a pedestrian sport. What
Wow, spoken like an Arizonan there, the Valley of the Sun. No, our family loves to ski together. That is one of our favorite activities. My daughters are ferocious double black diamond skiers. One of them is...
That's not pedestrian at all.
One of them is right now doing some backcountry skiing out near Telluride as we speak. So that's something we love to do as a family.
And where does your family vacation?
Near Winter Park, Colorado. It's a resort owned by the city of Denver. And it's where I learned to ski as a kid. My parents would put me on a bus or the train. It was their idea of getting rid of me for the day on the weekend. And I'd come back exhausted, which was good too. They like to run me ragged that way.
What's the largest trout you've ever caught?
Oh, now we're talking. All right, I love to fish. And that is where I find a lot of solace. You can't focus on the worries of the world when you're only worried about a trout. Everything else goes away, just disappears. And you're in the most beautiful, trout live in beautiful places.
They do.
They're very picky, and they pick well. So during the summertime, fishing, hiking, I like to row. I like to run. Those are my activities. And I like to read. I like to read novels. Good fiction. And if you want to learn how to write, you got to learn how to read.
That's right. That's great. Tell me about your civic involvement outside of the courtroom. You mentioned school board a while ago.
Yeah, boy, that I found taxing, and loved every minute of it. But I've spent a lot of my free time teaching or working on the Rules Committee. Been in the rules process for the last 6-7 years now. Chief Justice kindly appointed me to the Standing Committee and then to the Appellate Rules Committee more recently, and trying to make the rules more sensible so that we can get litigation done more sensibly, cheaper, faster for all people. It's a wonderful example of government working. People from a variety of walks of life, judges, lawyers, academics coming together and operating more or less by consensus. Imagine that.
Well, I've found that as well, and I think that typifies the West and small towns. I grew up in a town called Snowflake. I'm a 5th-generation Arizona, and you're 4th-generation Coloradan, I understand. That is how it works. People get along. They have to. And on a school board, there's no passing the buck there. You've got to make decisions. Local government is like that. Jury duty. Have you ever been called up?
You know, I have. It was when I was at the Department of Justice, and I thought for sure. Have you served on a jury?
I'll give him.
No, I just thought it was very odd questions for this, but it's great. It's
Well,
great.
you know,
it's nice.
you know, it
Thought it was
is.
pertinent. I wanted to know.
I'm
Can
a
a judge
big-
be called for jury duty?
I'm sorry I laughed. It caught me
No.
by something. Go ahead.
Thank you. I actually think it's a very excellent question, because I think anyone who served on a jury appreciates the important civic function that's involved. It's a way citizens are actually interact with their government, right, in a very real way.
Were you disqualified, or did
You know, I thought for sure I'd get kicked off. And I guess, you know, neither side thought I was the worst one. So I made it through, and I went to the bathroom when we sent back, and I came out and I'd been elected foreman, which I refused to serve as. But I just didn't think that was appropriate, and I didn't want to have undue influence. But, you know, the Seventh Amendment and the right to a trial by jury, the only disagreement our founders had over it was whether it was a bulwark of liberty or the very palladium of liberty. And as a trial lawyer, I had great faith in jurors, in the collective wisdom of 12 citizens to adjudicate a case fairly on the facts. And my time serving in a jury, I wondered, is it going to prove out my beliefs, or am I going to come out more of a cynic? I came out more optimistic and a truer believer in the jury system than ever. I really believe in the wisdom of juries.
Thanks.
That was a great question.
Thanks, Al. Yeah. Appreciate it. It's the end of the day, I see. You mentioned earlier that your colleagues on the 10th Circuit. Can you tell me about them? What do you admire about some of them? What have you learned from some of them?
Oh, there's so many I admire. I admire them all. They all bring something to the table. Men, women, from every kind of background.
Tell me how it works. Are you bunched up, or these were Republican-appointed judges, these are Democrat-appointed judges? Do you notice that? Do you forget that? How is it?
You know, the nicest gift I've gotten in the last few weeks, there have been so many prayers, so many well-wishers, so many kindnesses. But the best gift I've gotten was this enormous basket from my 4 most recent colleagues. I think it was 4, whatever. It just happens to be my Obama-appointed colleagues sent me a gift basket because they knew I wasn't eating very well as I was marching around the Senate halls, and they said I was looking a little gaunt. You know, that's how we work in the 10th Circuit. And I'm sorry for outing them, but you touch my heart. Thank you. And that's how my colleagues are, all of them. I've served with judges appointed by President Johnson, President Nixon, President Carter, President Reagan, President Bush I, Clinton, President Bush II, and Obama. And we get along. And I think you're going to hear in a couple of days from 2 former chief judges of the 10th Circuit who've retired now. And you're going to hear about how we operate in the 10th Circuit. It's often reputed to be the most collegial circuit in the country. Collegial not in some ordinary pedestrian sense of we're just nice to one another. Collegial in a real meaningful sense. We listen to one another, and we value and we respect different points of view, not just tolerate them.
Just for the record, the 10th Circuit is 7 active judges appointed by Democrats, 5 by Republicans. Yet of the 2,700 cases for which you have sat, you've filed dissents on just 36. Is that right? 1.3%. And of the 25 dissents that Judge Gorsuch has authored, more than half, 52%, were from majority opinions written by Republican appointees. So for those, and it's been said or implied that you act in a partisan way somehow, or that former work in the political arena before you became a judge, if that has somehow bled over into your judgeship, it certainly is not reflected in what the record shows. I think even more telling, as Congressional Research Service shows, 97% of the majority opinions that you authored were for a unanimous court. As you mentioned, you worked together. In over 98% of all cases in which you sat, there's this what you agreed with the majority result, 99% of the time. That does not sound like an ideologue. That does not sound like someone far out of the mainstream. And so when I hear that on television or whatnot, people say that this is a judge way out of the mainstream, it simply doesn't ring true from your record, with your record. Let me submit for the record a statement from a former law clerk. I think she was mentioned earlier. She said that soon after you took the bench on the 10th Circuit, he said, quoting, "He took all of his clerks and office staff, myself included, to visit several federal prisons. He wanted to see for himself, and he wanted all of us to understand the importance of applying justice in every case. For the lives of others depended on us doing the best job that we possibly could." Can you tell me about that experience?
Senator, federal criminal law imposes very long sentences. And to be a judge complicit in adjudicating criminal cases, I thought I couldn't close my eyes to what the reality is. And I wanted to see it for myself firsthand my first year on the bench. So I did.
Can you tell me about the 10th Circuit Capital Habeas Project?
Oh, Senator, I think it started one day after an argument when a few of us were concerned that the quality of representation of death row inmates in our circuit was not what we'd like it to be. And I do not want to take more credit than I'm due here. Real people deserve credit. My colleagues, Judge Timkovich, Judge Lucero, and a whole lot of our staff, Betsy Shoemaker, David Tye, many, many others, who put together with the wonderful judges in Oklahoma, some training sessions, recruited additional lawyers, provided training for those who are already in the system, sought and obtained more funds for federal public defenders to assist. And a lot of people deserve more credit than I do.
Well, thank you. Let's talk about Western issues for a bit. We talked about the importance of geographic diversity on the court, and people are saying, well, what does that mean? Is there really a difference? Is there really a Western perspective that somebody can bring? Let me go through a few of the issues that you've encountered, and we'll flesh that out. Let me introduce, for the record, a letter from one of Judge Gorsuch's former clerks. Well, also, let's do it from a federal judge in Montana. But let me talk about for a second some of the policies that come out. In one case, you rejected the idea that a dormant commerce clause prevents Colorado from requiring that 20% of electricity would come from renewable sources. Now, whether or not you agree with that policy, and there's a lot of disagreement around here about that, but we don't live in Colorado. You do. So its wisdom isn't really our business. Would you agree that the principles of federalism allow states to experiment with policies like environmental protection in this sense?
Senator, that was the holding of my court in that case. Colorado had passed by voter referendum a law that, as I recall, sitting here, indicated that 20% of energy in Colorado had to be from renewable sources by a date certain. That law was challenged by fossil fuel producers out of state, alleging that it violated what's called the Dormant Commerce Clause under the federal Constitution and case law interpreting it. And I did write for a unanimous panel that there was no constitutional violation and the state was permitted to proceed with its experiment.
Is that indicative of the concept of laboratories of democracy that states have been described as?
Consistent with that principle.
All right. Well, thank you. One complicated issue that we have in the West that you really don't get as much elsewhere is the split estate property rights. It's possible that I might own a parcel of land, but somebody else might own the mineral rights, and still somebody else might own the water rights. Have you encountered that in your jurisprudence?
It is very different than out here. And yes, I have. Split estates, as you know, are a common feature in the West, and in part, at least, a byproduct of homesteading acts by this Congress, where initially, as I recall, Congress gave homesteaders rights down to the center of the earth, as is common out here. Mm-hmm. Then they found out, my gosh, there's some valuable stuff under there, and they started splitting the estates so that homesteaders could do what they wanted to do on the surface estate, but that the Congress and the people could control some of the valuable mineral rights underneath. Very complicated stuff. Yes, I've encountered those cases too.
Is that a perspective that you think would be useful on the Supreme Court?
I think that's for this body to decide.
All right. Well, thank you. Also, another aspect of living in the American West is we share a lot of land with the Indian tribes. And the prevalence of tribes out west can complicate things in the legal sense. Say, deciding between municipalities or local or state government. What have you ruled on or have you dealt with in terms of relationship between state and local government and the tribes?
Senator, I've had a number of tribal cases. And tribes are, as you know, sovereign nations. And our constitutional order affords this body considerable power in dealing with those sovereign nations, by treaty and otherwise. And out west, there are all sorts of variations on that arrangement. There are classic reservations, as many people in the East conceive of them. There are also ancient pueblos that predate this country by many hundreds of years. Then there are allotments to individuals and groups. Depends where you are. That sounds like Oklahoma. Pueblo sounds like New Mexico. Mm-hmm. And then when I think of reservations, I think of Utah and some places in Colorado and Wyoming. And there are variations all throughout the American West. Mm-hmm. You know, our history with Native Americans is not the prettiest history. And as a judge, you try very hard to administer the law fairly without respect to persons and equally. And I'd point you maybe to my cases involving the Ute Indian tribe, where they've had a long time trying to control their tribal lands. Or Fletcher, involving the Osage Nation in Oklahoma, and the right to an accounting of the property due them under agreements with the United States. Try to treat all persons who come before me fairly.
That's also a perspective that a Western member can bring to the Supreme Court. That's my supposition. I know you won't say that, but I think that that's useful. While the chairman is here, let me ask for unanimous consent to enter a record, or into the record, a letter from Alaska senators on behalf of Indian tribes.
Yes.
Also, one from a law school clerk, and also one from a judge in Montana.
Those documents, without objection, will be entered.
Thank you. Let's turn for a minute to the separation of powers. You've written eloquently about Chevron deference and your concerns. I share those concerns. Chevron didn't come out of nowhere. There were serious concerns in the 1980s with rogue judges making policy from the bench. Now, the idea of agency deference was designed to restrain judicial overreach. I think that the pendulum has swung far too far in the other direction, and that the judiciary is insufficiently vigilant of executive overreach. What are your thoughts on that?
Senator, those are policy considerations. As a judge, my job is to look at the law. I would say I don't conceive of Chevron deference as conservative or liberal issue. I do recall when Chevron was announced, many people thought it was a very conservative decision because it does advantage whoever has their hands on the reins of the administrative state at the particular time. And in 1984, that was one party. Today, you know, maybe another party, and the next day it may be another party. So a good judge doesn't care who it advantages. A good judge looks at the law.
So setting the boundaries for where deference ought to be is the job of the legislature and not the judicial branch.
Well, in the first instance, the Administrative Procedures Act is the statute that you look at.
Right. Thank you. With regard to the Second Amendment, you've been asked about stare decisis and the role of precedent, and it's usually by those who talk about Roe versus Wade or decisions like that, but they rarely bring up that might also apply to Heller or other decisions like that. How do you see it with regard to precedent?
All precedent of the United States Supreme Court deserves the respect of precedent, which is quite a lot. It's the anchor of the law. It's the starting place for a judge. And the chairman kindly held up my overlong book, right? And that's the law of precedent, a very mainstream consensus view by a bunch of judges from across the country got together, and we wrote it down, and it's all in there. And Justice Breyer was kind enough to write a foreword to it, and it articulates how a good judge goes about assessing the law of precedent in any case.
Thank you. Let me just close with religious liberty, religious freedom. I would not ask you your religion or how you practice your faith. But if you can just talk in general about what the role of faith is, or people of faith coming into the judiciary or on the courts. What role should it play? What role should it not play, in your view?
Senator, one of the wonders of our constitutional order is the First Amendment and the right of free exercise. Not many countries in the world are as pluralistic when it comes to religion as this country. It's quite an experiment, really. Right? Most nation states, one culture, one people, one religion. We're founded on a very different idea, that all voices are heard, that people of all faiths and no faiths are welcome, that we're tolerant. It was quite an experiment to launch 200 years ago. It's still an experiment today that we're working on and learning to live with one another and mediate it. So the role of religion in our society is profound and always has been. And it's a pluralistic commitment we have in this country that's, very special in the world.
Mm-hmm. Well, thank you. Well, Mr. Chairman, I'll do something very unsenatorial. I've got a couple minutes left, but I'll yield back so people can go vote.
Yeah, okay.
Or is he's not back?
I'll stay here. I think Senator Blumenthal will be here for, I'll stay here just a few minutes, so we will just stand in recess. I hope everybody will kind of stay close by.
Thank you, Mr. Chairman.
The Senate Judiciary Committee taking a bit of an unexpected break. Chairman Grassley had said they wouldn't break for the vote in the Senate, but they have. Some senators called away for that vote, dealing with a resolution overturning an Obama administration rule, something that had already been passed in the House. It's the Senate voting now, and they should gavel back in shortly. Nearing the end of day 2 of the confirmation hearing for Neil Gorsuch to be a justice on the Supreme Court. This is the first day of questions for Judge Gorsuch. Tomorrow they'll begin at 9:30. Our live coverage will as well here on C-SPAN 3, and a round of 20-minute questions tomorrow. So another fairly long day ahead, and the hearing should wrap up on Thursday as the committee hears from supporters and opponents of the nomination. Chairman Grassley announced as the week began that the committee expects to vote out the nomination of Judge Gorsuch on April the 3rd, hoping to get it to the Senate floor ahead of the Easter recess. So our live coverage will resume here on C-SPAN 3 when they gavel back in.
Senator Blumenthal, I'll call on him. And Senator Blumenthal, while I'm gone, if you have anything that you want to put in the record, just ask your permission to do it, and you can do it.
I thank you very much, Mr. Chairman. I have 2 sets of documents, and with your permission, I will enter them into the record.
Yes, okay.
Thank you.
I'm going to go vote now.
Just us.
Good evening, Your Honor, and thank you for your patience and your perseverance with us. You'll recall the conversation or visit we had in my office not that long ago, and you will, I'm sure, recall that I quoted the first line in your concurrence in the case of Gutierrez v. Brizuela. You remember that first line?
Senator, I'm sorry, I don't remember the first line. But
the line was, "There's an elephant in the room with us today."
Yes, yes.
It's been cited before.
Yes,
today.
yes.
And do you recall what I said or who I said was the elephant in the room?
I'm sorry, Senator, I don't. I apologize sincerely.
I'll refresh your recollection. The initials are DJT.
Okay.
Donald Trump.
Yep.
He was the elephant in the room with us then. I think he's the elephant in the room with us now. And the reason is, as I said then, because of his attack on the judiciary. And make no mistake, I am not in any way attributing to you that attack, but you are familiar with the fact that he referred to the Article III judge who ruled against him in the travel ban case as a, quote, so-called judge in one of his tweets? You recall?
I do.
Tweet? And do you recall his second tweet when he referred to the court and said that they were to be, quote, given blame if an act of terrorism occurred because of striking down the travel ban? You recall that tweet?
Yeah, yes, Senator.
And during the campaign, a completely different federal judge, born in this country, he said could not rule fairly on his case because the judge was, quote, a Mexican. You recall that?
I do.
What do you think the president meant when he used the words so-called judge?
Senator, I don't know what was in his mind. You'd have to ask him.
How would you feel if he called you a so-called judge?
Senator, I care deeply about the independence of the judiciary. I can't talk about specific cases or controversies that might come before me. And I can't get involved in politics. But I can say a couple of things about that, as you know. The first is, judges have to be tough. We get called lots of names all over the place. We have to accept criticism with some humility. It makes us stronger and better. I take it from my teenage daughters. I take it from litigants. This process, there's been plenty of criticism, and that's fine. Thomas Jefferson didn't much like Marbury versus Madison, and he didn't mind saying so. Presidents have tried to pack the court. That's part of our constitutional history. We have a First Amendment. People can speak their mind. But Senator, I'm sorry, I don't mean to interrupt, but I did want to add one other point, if I may.
Please do.
But Senator, when you attack the integrity or honesty or independence of a judge, they're most we sometimes hear. Senator, I know the men and women of the federal judiciary, a lot of them. I know how hard their job is, how much they often give up to do it, the difficult circumstances in which they do it. It's a lonely job, too. I'm not asking for any crocodile tears or anything like that. I'm just saying I know these people, and I know how decent they are. And when anyone criticizes the honesty or integrity, the motives of a federal judge, well, I find that disheartening. I find that demoralizing, because I know the truth.
Anyone, including the President of the United States?
Anyone is anyone.
Because no person is above the law, including the President of the United States.
That's right, Senator.
And isn't that reference by the President to a so-called judge, isn't his attack on the same judges who struck down that order as playing politics? Isn't that an attack on the judiciary, on its integrity?
Senator, I can't comment on specific cases, and I can't get involved in politics. I've said what I think I ethically may in this area.
Well, maybe you can share with the President what that wise old judge told you. Maybe you can quote it to us again.
I think you're going to hear from him yourself on Thursday. And I'm sure he won't mind to hesitate or in any way have any question of fear about saying it to you himself. But I'm happy to share it with you, too.
The ultimate test of
the rule of law is whether the government can lose in its own courts and accept the judgments of those courts.
And in your view, was the President of the United States showing proper respect when he attacked the courts in that way? Was he accepting the rule of law?
Senator, I've gone as far as I can go ethically with the canons that restrict me about speaking on cases. I can't talk about specific cases, and I can't get involved in politics. Respectfully, I believe I've gone as far as I'm able to go.
Well, I just want to make clear that I'm looking for the same kind of expression of outrage that I felt as an officer of the court, and I am still an officer of the court because of that attack. Because as you well know, and I cited it yesterday, Alexander Hamilton said the courts are the least dangerous branch because they have neither the power of purse nor sword. What they have is respect. When the President of the United States attacks the court, attacking you, because when he attacks your brethren, he attacks you, the bedrock of our democracy, you as a member of the 10th Circuit Court of Appeal, as a so-called judge. He undermines the bedrock of our democracy, which is respect for the courts. Courts don't have armies, they don't have police forces. All they have is the respect and credibility. And you made reference earlier to judges having to take the barbs and insults. My guess is that if a litigant before your court, and the President of the United States was a litigant in that case, used that language, you might well entertain a motion for contempt of court.
I appreciate the opportunity to talk about my record, because I can talk about that, Senator. My record is when there's a judge who's accused of perhaps using language that might bear on a man's ethnicity, arguably, in the course of sentencing. A panel of my court on which I sat replaced it. My record is that when an undocumented alien, immigrant, is not properly represented, and there's a history of the lawyer failing his clients in that area, send him, referred him for dismissal from our bar.
Because you believe that respect for the courts is important.
Senator, the independence and integrity of the judiciary is in my bones.
Well, I'm going to return to this topic, maybe not in this round, but later, because as you well know also, although judges may be attacked, they really have no way to defend themselves. And we know that as officers of the court, as advocates. And that's why I feel so deeply that not only we, but the Department of Justice should have been more vigorous in coming to the defense of those judges, even though the Department of Justice was the loser in that case. Because more is at stake here than the President's immigrant or policies or the travel ban. It is the respect and integrity for the courts. There's another reason that Donald Trump is the elephant in the room, and that is because he established a litmus test, or actually a set of litmus tests, one of them being that his nominee, and I don't know whether you saw the debate, the third presidential debate, where he promised, and I'm quoting, about overturning Roe v. Wade, quote, "That'll happen automatically, in my opinion, because I am putting pro-life justices on the court." Are you familiar with that statement?
I am, Senator.
Are you familiar with other occasions when he promised that he would appoint someone who would overturn Roe v. Wade? For example, November 13, 2017, in an interview with Leslie Stahl on 60 Minutes, quote, "I'm pro-life, the judges will be pro-life." On June 28, 2015, an interview on CNN with Jake Tapper, quote, "I'm pro-life." He was then asked, would that be a litmus test? Quote, it is, end quote. There are others, but what I'm asking you is, you're aware of that litmus test.
Senator, I can't say I'm aware of each of those statements, but I'm definitely aware that there was discussion of litmus tests by lots of people during the election process. Yes.
Well, these discussions are by the President of the United States,
yes,
who has nominated you for this position.
Very aware of it, Senator.
And he interviewed you.
He did.
And you've testified here that there was no mention of Roe v. Wade.
Senator, what I've testified to is that there was no request for me to commit on any case or controversy or anything that might come before me.
Was there any mention of Roe v. Wade?
There was, briefly.
And what did he say and what did you say?
Yeah. Senator, the President recounted to me, among other things, how the campaign went in Colorado. He knew I was from Colorado, and he was disappointed he had lost Colorado. And he said something like if he'd had a little more time, he thinks he might have won it. And then he said that one of the topics that came up during the course of the campaign was abortion, and that it was very divisive and split people evenly, he found. And then he moved on to other topics.
Did he mention Roe v. Wade by name?
I don't think so, not to my recollection, just that abortion was very divisive, and then he moved on to other topics that are of interest to him.
Like what?
Senator, the next topic I remember, and this is just my recollection, is he expressed concern that our country's nuclear armaments are old.
Has anyone in interviews with you, and you mentioned one conversation with Steve Bannon, I understand you also met with other advisors, has anyone else ever mentioned Roe v. Wade?
No, Senator. That's it.
Never a mention of that case or of abortion in any of your conversations with any of the President's advisors?
Not to my recollection, no.
And what about with officials of the Heritage Foundation who may have discussed the Supreme Court with you?
To my knowledge, Senator, from the time of the election to the time of my nomination, I've not spoken to anyone that I know of from Heritage. Maybe I shake someone's hand, but I've not had any substantive conversation that I'm aware of that anyone's alerted me to that they're from the Heritage Foundation.
Well, let me go to a case that I think bears on perhaps the President's and his advisors' perception of your views on Roe v. Wade and on this issue of abortion. I don't know whether you recall the case of Planned Parenthood Association of Utah versus Herbert.
I do.
In that case, as you know, the governor of Utah directed all of his state agencies to end funding for the local Planned Parenthood affiliate after a deceptive and false set of videos was released. And Planned Parenthood of Utah went to federal court. They sought a temporary injunction. They won. They lost at the district court, which denied their request. And then on your court, a 3-judge panel reversed the district court and granted the injunction, stopping the state government from terminating the funding. That restored the funding for Planned Parenthood.
Temporarily, as a preliminary matter, that's my recollection, yes.
As a preliminary matter, the panel of the 10th Circuit restored the funding.
Issued a preliminary injunction or a TR, probably preliminary injunction. Yeah.
Correct. Preliminary injunction is correct. Were you on that panel?
No, no, Senator, I was not.
Okay. And any of the parties subsequently have the right to ask for a rehearing, do they not?
They do.
Is there a time limit?
For the parties, there is a time limit prescribed by rule. It's also possible for the court, what we call sua sponte, or on its own, to seek rehearing, and there's no time limit prescribed by rule for that.
So the time limit for the parties is 2 weeks, correct?
That sounds right, Senator. I wouldn't swear to it, but I trust you.
Well, I would never presume to know the rules.
I always check the rules on that sort of thing because I always think I know, and it's 10 days or 14 days, or so I always look.
I'm sure you do. Well, 2 weeks passed, and none of the parties requested a rehearing, correct?
That's right. That's right.
But one of the judges did.
That's right.
That judge was you.
Senator, that's internal deliberative process that wouldn't normally be revealed, but I have no problem acknowledging that.
That you asked for the rehearing.
I did.
the parties actually were fine with the result. They settled a case. They were off about their business, and you asked for the rehearing, correct?
No, Senator, that's not correct.
Well, correct me.
A preliminary injunction, the Court of Appeals, the panel had indicated should issue, subject to the district court has to enter it, I believe. I don't think our court entered it directly. As I recall, the parties either reached some sort of agreement with respect to the preliminary relief, or the court entered it. I don't recall which, but the case proceeded. It may still be proceeding for all I know.
But one way or the other, none of the parties asked for any further proceedings, only you did.
That's right.
And did the court decide to grant an en banc hearing?
Very narrowly voted against it, Senator. It was a close vote.
And you dissented?
I did.
Now, you know Rule 35 says, and I'm quoting, an en banc hearing is not favored and ordinarily will not be ordered.
Oh, of course. It's an extraordinary thing. We probably hear between 0 and 3 en bancs a year over the course of my time. Don't hold me to that, but it's somewhere in that range usually.
Out of your 10-plus years, 11 years on the court, how many times have you asked, you yourself, sua sponte, asked for a rehearing in a case where you were not even on the panel?
Oh, I've done it, Senator. I can't tell you how many times sitting here. I just can't. But I can tell you I've done it. And I can tell you, Senator, that about 1 out of every 5 en bancs, about 20% of en bancs in our court are sua sponte. It's not unusual.
By this time, the funding was going to Planned Parenthood, correct?
I don't know. I don't know. I don't
it is
know.
a matter of, I believe, public record that it was, in fact, restored. And the parties never asked for that en banc hearing. Let me ask you, what was the exceptional importance of this case that prompted you to seek a rehearing en banc?
I appreciate the opportunity to answer that question, Senator. En banc rehearings happen sua sponte with regularity in our court. As I say, maybe 20% estimate of the cases that we've heard during my time have been sua sponte. It's acknowledged in the committee reports to the rules. Wright and Miller, the Bible on civil procedure that every young lawyer lives with, acknowledges the regularity and the propriety of sua sponte en banc. So just to put that aside, I just don't see any.
I'm asking you about your reasons.
And now,
and by the way, I know you don't have a number, but maybe you can supply it, because I'm willing to bet that that number is a tiny, minute fraction of the 2,700 cases.
Of course.
And even of all of the cases where you have dissented.
Of course. I'd be very reluctant to reveal internal deliberative processes any further, Senator, of a court, and I don't think you want us to, but I've gone pretty darn far here, and I'd be happy to consider any reasonable request that we can talk about that.
By the way, the judge who dissented from the panel opinion was Judge Baccarat, correct?
Yes.
He voted against the rehearing en banc, didn't he?
He wrote a special concurrence saying that he thought the panel decision was gravely wrong.
But there was no exceptional reason for a rehearing en banc.
He decided not to vote for en banc. That's correct. But he thought the panel opinion was gravely wrong.
I'm going to...
And Senator, if you want me to explain why I sought en banc and the reasons, I'd be delighted to do so.
Well, I'm going to give you the opportunity to do it.
I appreciate it.
And I apologize for interrupting, and you'll understand our time is limited, and that's why I'm sort of pressing to move on.
I understand, but an implication of impropriety,
Exactly.
anything like that, Senator, I'd appreciate the chance.
Absolutely.
Okay.
I'm not even asking for extra time, Mr. Chairman.
Senator,
please proceed.
Yeah, Senator, it's all about standards of review for me. In that case, the parties agreed on the law. There was no dispute of law. In that case, everyone agreed that if the governor had discontinued funding because he opposed lawful abortions, that would be unconstitutional and wrong. and would have to be stricken by the court. That was uncontested. It was also uncontested that if the governor discontinued funding because of his reaction to videos that you're well aware of involving alleged unlawful action, alleged, then his conduct was lawful and constitutional. The law was agreed by everyone. The only question was, what was the governor's intention? That's it. And the district court made a factual finding that the governor's intentions were what he said they were, that he acted in response to the videos. That was his testimony. That was the district court's finding. And in a very unusual, I thought, step, our court overturned the factual finding of a district court and did so on the basis of a putative admission from the governor's brief, as if the lawyers for the governor would concede away their case. I read the brief. It didn't concede away the case. And it seems to me very important, Senator, that we abide our standards of review. And we don't pick and choose the areas of law to start abandoning our standards of review. And the standard of review for clear error, for factual findings, is what I wrote about. And I don't care if the case is about abortion or widgets or anything else. When a jury or a district judge makes a factual finding, that deserves our respect under a clear error standard review. And as you point out, Judge Bacharach, while he didn't think that rose to the level of en banc review, he thought the panel was clearly wrong. And he happens to be, as you know, just happens to be a democratically appointed judge, because we're judges first. And Senator, there were 4 judges who wanted en banc in that case. That's a large number in our circuit. There's nothing unusual or untoward about that case at all. It's what we do as judges.
Do you recall the date of your dissent?
I don't, Senator.
Would it surprise you to know that it was, well, the case was pending in July of 2016. Your dissent was sometime in that time period at the height of the presidential campaign.
I would have said it was in the summer, Senator, yes. I would say I've also, Senator, revived partially a lawsuit brought by Planned Parenthood in another case. I take the parties as I find them, and I take the facts and laws that come to me. And I don't choose when they come to me or how they come to me.
I understand.
And any other implication would be erroneous.
Let me ask you, we talked about precedent, and precedent is important as law, correct?
Yes.
And people rely on it. That's one of the key criteria that you've established for sustaining precedent, and I'm not even sure that the term has been used here, but stare decisis, which is an important principle of following well-established and accepted law. Let me ask you, did you agree, or do you agree with the result in Brown v. Board of Education?
Senator, Brown versus Board of Education corrected an erroneous decision, a badly erroneous decision, and vindicated a dissent by the first Justice Harlan in Plessy versus Ferguson, where he correctly identified that separate to advantage one race can never be equal.
And do you agree with the result?
In Plessy, no, absolutely
No, you agree
not.
with the result in Brown v. Board?
Brown versus Board of Education, Senator, was a correct application of the law of precedent. And
So you agree with it?
Senator, it is a correct application of the law of precedent.
By the way, when Chief Justice Roberts testified before this committee, and he was asked by Senator Kennedy, quote, do you agree with the court's conclusion, meaning in Brown, that the segregation of children in public schools solely on the base of race is unconstitutional? Judge Robert answered unequivocally, quote, I do.
Senator,
would you agree with Judge Roberts?
Senator, there's no daylight here.
Okay.
Justice Harlan got the original meaning of the Equal Protection Clause right the first time. And the court recognized that belatedly. It's one of the great stains on the Supreme Court's history that it took it so long to get to that decision. It
Do you agree with the court's this outcome, the result, in Griswold v. Connecticut and Eisenstadt v. Baird? And you know that they struck down a ban on contraception. I believe it's been discussed earlier. Yeah. So, do you agree with the result in those cases?
So Griswold, Senator, as you know, held that the 14th Amendment due process liberty clause provided a right to married couples to the use of contraceptive devices in the privacy of their own home. And then Eisenstadt extended that to single persons.
Right.
Senator, those are precedents of the United States Supreme Court. They've been settled for 50 years, nearly, in the case of Griswold. There are reliance interests that are obvious. They've been reaffirmed many times. I do not see a realistic possibility that a state would pass a law attempting to undo that, or that a court of the United States would take such a challenge seriously.
I have a very simple question for you. Do you agree with the result?
Senator, I'll give you the same answer.
Again, I just want to tell you what Justice Alito said in response to that question. He said, very simply, talking about Eisenstadt, quote, I do agree with the result in Eisenstadt.
It was an application of equal protection principles.
Well, I know what it was. I'm asking you for a direct, clear, unequivocal answer.
And Senator, I'm trying to give it to you, and as I recall, Justice Alito said the same thing, which is that there's an equal protection argument. Once you have Griswold in place, then it follows, as a matter of equal protection, that the same, what was true for married couples is true for single persons, and that was an application of settled equal protection principles.
I want to tell you what Chief Justice Roberts said when he was asked the same question about Griswold. He said, quote, I agree with the Griswold court's conclusion that marital privacy extends to contraception and availability of that. My time is about to expire. I just want to say I hope that when we resume questioning, that perhaps you can give me somewhat more direct and unequivocal answers in the same way that Roberts, Alito, Justices Roberts and Alito and Kennedy did to the same questions. Thank you, Mr. Chairman.
Senator from Idaho.
Thank you, Mr. Chairman. And Judge Gorsuch, first of all, I want to thank you for preparing yourself for this opportunity and for this service to the United States. You have acquitted yourself very well today. In fact, I'm very impressed with your knowledge of the cases and your ability to understand and articulate your positions on the issues. I have a couple of tough questions for you first. Is it true that you have been endorsed by John Elway?
You know, Senator, a couple of things have made my day recently, and hearing that was definitely one of them. You know, in Colorado, I mean, where I come from, that's big stuff.
Well, it is. And, you know, some of us Westerners who don't have a pro team in our state kind of agree with that as well.
Senator, I'll tell you, what meant as much to me, though, was an article I saw not too long ago someone put in front of me from the Albuquerque Journal. And it quoted two lawyers who appear in front of me all the time. One's a civil rights attorney. The other represents indigent criminal defendants, routinely in my court. They win some, they lose some. And they both went out of their way to say, he's a fair judge. And you know what? The compliment of the people who work with me day in and day out, who win some and who lose some, that means the world to me.
That's very impressive. And at the end of my opportunity to ask questions here, I'm going to submit a statement for the record that has been submitted by another one of your associates and friends who endorses the way you have conducted yourself on the bench. It's good to have good friends who will stand up for you. Another tough question. I appreciated the discussion that Senator Flake and you had about fishing. This is going to test your true abilities as a fisherman. Would you tell me where your favorite fishing stream is? And don't say No Tell'em Creek.
Do I have to answer this question, Mr. Chairman?
No, you don't have to answer it. At least not publicly.
I'd be happy to share with you privately my views on this subject.
We'll talk.
My experience is, though, that once the word gets out,
Then it's not.
then it's not my favorite spot anymore.
Okay, you've just proven yourself as a fisherman. I also wanted to just tell you, I appreciated the conversation you had with one of my other colleagues here about your law clerks. I, too, am a law clerk. I don't know that you knew probably the judge I worked for, Judge James M. Carter, on the Ninth Circuit. He passed away in 1979. He was appointed by Harry Truman to be a district judge in Southern California, and then by Lyndon Johnson to be a circuit court judge on the Ninth Circuit. And I had the experience as his law clerk that you described your experience to be, and those who serve as your law clerks. And I just wanted to tell you, you connected with me on that. I truly appreciated that bit of just learning more of your human side in that context. I want to go, this is also a point in this hearing that pretty much everything has been said, but not everybody's gotten an opportunity to ask you to say it. And I apologize if some of the things are repetitive, but some issues keep coming up. And I want to get back into some of the core issues and just give you an opportunity to restate the case. And a couple of those are pretty obvious. In fact, our chairman started out with this first issue, and that is, what is the role of a judge? I have before me here the statutory oath that we give to judges. I'll just read part of it. It is to administer justice without respect to persons and do equal right to the poor and to the rich. And it also says to faithfully and impartially discharge and perform all the duties incumbent upon the judge under the Constitution and the laws of the United States. That's some pretty high-minded language. What is your opinion of the role of a justice on the Supreme Court?
Senator, it's the same thing. Doesn't change. It's a more public role. There may be more civic education involved, or at least an opportunity. Somebody might listen to you a little bit more. And Justice O'Connor, again, comes to mind here. But the job doesn't change, and the law is the law. It's what we do day in and day out. And the discussions about the judiciary, I think, often miss the fact that judges agree overwhelmingly on the disposition of cases. Tiny percentage of the cases go to the Supreme Court of the United States, 70, 80 cases a year, a fraction of a percent. And even then, the justices of the United States Supreme Court are unanimous in their decisions 40% of the time. Now think about that. You have not just 3 judges who have to agree, as on the Court of Appeal, generally speaking, but 9. 9 justices who are appointed by 5 different presidents right now. And people say the world's changed. But in some ways, it hasn't, because that 40% number has been remarkably steady since the Second World War. That's a pretty incredible thing when you think about it. That's a testament to our rule of law. It's human, it's imperfect, but it's sure better than anything else anybody's ever devised.
Well, that commitment to interpreting and applying the law honestly, fairly, and impartially is critical. It's what we need in Supreme Court justices. And again, I appreciate your answer on that question. Now, again, I apologize that this is a repetitive question. In fact, you were just asked it in another way just now, but it's one that keeps coming up and which I expect is going to be a discussion point for the rest of this process, and that is the litmus test issue. You've already said it, but I'm going to ask you to say it again. Did anyone in the nomination process, the president included, require of you a commitment of any kind of a litmus test as to how you would rule on any issue and in any case whatsoever?
No, Senator, and if they had, I would have walked out of the room, period.
So to put it another way, if you had to, you would, if the requirements of the law were that you had to rule against the President of the United States in a case, you would do so?
Senator, if that's where the law and the facts lead me, do it without hesitation. I've done it. I've done it many times without respect to who is in charge. I rule for the government sometimes. I rule for the accused, for the prisoner, for the immigrant, for the student, for the employee, whomever it is, based on the law and the facts of the particular case at hand. And I believe respectfully my record demonstrates that.
I think it does too. And there has been some questioning here today about, this is my characterization of it, but I think it's pretty clear, a desire to get you to get involved in the politics of the court, as though there is an appropriate role for a judge to be a politician or to be involved in politics. I remember in our meeting in my office, you were quite emphatic about the fact that you would not let your politics get into your job as a judge or a justice. Could you comment on that?
Senator, it really comes from my experience as a lawyer. And General Cottrell put it better than I could. But the fact of the matter is, I represented plaintiffs, I represented defendants, I represented the big guy, I represented the little guy, however you want to call it. And in each and every case, all I wanted was a judge who didn't decide the case based on his personal beliefs, her personal religion, his politics, what she had for breakfast. I just wanted someone to come in and look at the law and look at the facts, study it as hard as they could, and make as neutral and dispassionate a judgment as they could. That's what I wanted. A human judge, somebody who's a person. It helped if they were kind, but I'd take a curmudgeon. There were some curmudgeons. Fair curmudgeon any day of the week I'd take.
Yep.
I wanted fair judge. And I resolved to myself that I would remember, so long as I was on the bench, I would remember what it was like to be in the well, what it was like to have to make the arguments. Because I'll tell you what, asking the questions, a lot easier than having the answers. I sleep a lot better the night before argument as a judge than I did the night before argument as a lawyer. And so I resolved I wanted to be the kind of judge that I wanted when I was a lawyer.
Well, thank you. Now, let's move on to the question of precedent. Could you generally, again, I realize this is repetitive, again, tell us your view of precedent, particularly as a Supreme Court justice, if you are to be confirmed, what you believe the proper role of precedent is?
Senator, precedent's the starting point for any good judge. Precedent is our history, our shared history, our patrimony, the wisdom of the ages, if you want to think of it that way. And it would be foolish of any judge to come in and think that he or she knows better than everybody who's come before him. That'd be an act of hubris. So the starting point and the great anchor of the law, as Francis Bacon called it, is precedent. As Hamilton said, judges, because we're life tenured, need to be bound down by strict rules and precedents. And I take that obligation seriously.
So that people can know what to expect out of the law.
Reliance is a huge part of it.
Now, it does turn out, particularly at the level of the Supreme Court, that there are times when precedent is revisited. Could you tell us when it is appropriate? How does a person, particularly a Supreme Court justice, how should a Supreme Court justice approach that question?
The same way a circuit judge approaches the question with circuit precedent. We do the same thing. Nothing changes. It's the same set of principles.
So what process do you go through to make the decision that you should revisit precedent?
Start with a presumption in favor of history, and that people who came before you were just as smart or maybe even smarter than you are. When you put on the robe, you lose the ego. You look at the reliance interests that have formed around the precedent. You look at how long it's been around. You look at, see whether it's been reaffirmed. You look at the quality of the initial decision. You look at the doctrine and whether it's been built up around it or whether it's eroded away. You look at workability. Those are some of the factors a good judge looks at. when deciding any challenge to a precedent.
And I assume it's not a decision reached lightly.
Senator, no decision should be reached lightly as a judge.
Well said. I want to move on now to one that you have been asked a little bit about today, but not a lot, and that is the 10th Amendment to the Constitution, which says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, and I think some people stop there, or to the people. This is the issue of federalism. I've got a few specific questions, but could you just discuss with me in general your feelings about that amendment and what it means in our American jurisprudence?
Well, Senator, it's part of the Bill of Rights, like all the rest of the Bill of Rights. And it was thought important to add as part of the first 10 amendments to the Constitution as a package. And the thought was to emphasize and make very clear that the federal government is a government of enumerated powers, not a plenary government with unenumerated, unlimited power, and that there was reserved to the people and to the states abundant rights.
I agree with that. A lot of my constituents, and frankly, a lot of people that I talk to around the country, believe that that has pretty much been eroded in the sense that the place where there is authority reserved to the states is a very small place today. Because of certain Supreme Court rulings, because of certain doctrines relating to the Commerce Clause and others, it is felt that the place in which the federal government is free to assert its authority, even to the point of superseding state authority, is so large now that the 10th Amendment has lost much of its meaning. Could you comment on that?
Well, Senator, 10th Amendment cases do come before the court, and related Commerce Clause challenges that are kind of an analog here. So I have to be careful.
Understood.
But I'd point you to the New York case, Justice O'Connor again, pointing out that there are limits to how far the Congress and the federal government may go to commandeer state governments. And then, of course, there's the Chief Justice's opinion in the ACA case with regard to Medicaid expansion and the limits of the Commerce Clause power there. So there are a couple of decisions that are out there that you're aware of that discuss this issue.
I think that the discussions that have been had today about the Chevron case get into this arena. Earlier, when you were asked questions about it, you indicated that in your, and again, I realize you may not be able to go very far in this answer, but I'd like to give you an opportunity to explain it as much as you can. I believe in the decision that you wrote, you said the elephant in the room was the question of deference to executive agency actions. That's a rough paraphrasing of what you were discussing. And I believe you said that there were due process, equal protection, and separation of powers issues related to that. Could you expand on that a little bit?
Well, Senator, I'd be happy to, of course. In that case, again, involved an undocumented immigrant. And the question was whether an agency could overturn judicial precedent retroactively so that this man who had relied on our precedent essentially had the legal rug pulled out from underneath him. And it seemed to me that that raised a variety of questions. First, it meant now that he had to wait not 10 years outside of the country, but perhaps 13 or 14, because they wanted to retroactively overturn judicial precedent. And I ask, in terms of fair notice, advance notice, due process, how is a person, the least amongst us, anyone, supposed to organize their affairs, rely on the law, precedent, if it can be overturned by an agency willy-nilly? What are the equal protection implications if the person who declares the law is now a political branch rather than the judicial branch, where selective picking and choosing of winners and losers can be had in the application of the law. I'm worried about that. I worry about the separation of powers. How is it that an agency can overturn a judicial precedent effectively without the concurrence of Congress? Congress, of course, has the power to write statutes. Last time I checked, that's the legislative power, though, and overturn judicial precedents on statutory interpretation. That's this body's role. So those were some of the things I worried about, and I worried about just the plain old statutory text, too, of the APA, in which Congress is assigned the task, of course, of fact-finding to the agencies, and told us, again, to provide a highly deferential standard of review to the agencies, the chemists, the biologists, the scientists, but said when it comes to interpreting the law, that the courts are supposed to do that. So those were some of the questions that I found difficult in that case.
Well, I appreciate the perspective that you have. Again, still talking about federalism and the 10th Amendment, you're familiar with the Dormant Commerce Clause concept?
Yes.
Could you describe what that means to you?
Well, the Commerce Clause appears in Article 1. Article 1 affords this body and the House of Representatives the power to legislate interstate commerce, among many other things. That is the Commerce Clause, the non-sleeping, the non-dormant Commerce Clause.
Right.
But we have this sleeping thing over here. And it's the product of judicial interpretation that suggests that sometimes, even when Congress hasn't exercised its powers under the Commerce Clause, states infringe Congress's authority by stepping into the regulation of interstate commerce themselves in a way that, though Congress has not itself prescribed, would still offend congressional authority. That's the doctrine.
Correct.
Okay.
So that's how I understand it as well. And I realize that you may not be able to go much further in discussing your feelings about that doctrine, but if you can, I welcome you to.
Well, Senator, I've tried to make clear today that my feelings, respectfully, on any of these topics are things I try to leave behind. And I try to take the facts and the law and the precedent before me very seriously. I come here with no agenda but one. No promises but one. To be as good and faithful a judge as I know how to be. That's it. And I can't promise or agree or pledge anything more than that to this Congress. I just can't. Not as a good judge. Not as someone who has to look litigants in the eye and tell them I'm a fair and impartial judge of their case. Not as someone who respects the separation of powers. So that's where I come from on that.
Thank you very much, and I respect that. And frankly, America is very fortunate to have someone who strongly holds to that perspective nominated to this critically important position. I just want to clear up one other thing, and then there's a few issues I just wanted you to also discuss a little bit further with me. Back to the Hobby Lobby case, I just wanted to give you an opportunity to clear one thing up, at least for me. Maybe everybody else understood this very clearly. That case went to the Supreme Court and was resolved in a 5-4 decision. But if I understand the rulings correctly, of the 4 judges who dissented, only 2 of them felt that the issue relating to a for-profit corporation was dispositive. Did I get that right? Or objected to that part of the ruling. Is that correct?
That's right. The other 2 dissenters did not feel the need to reach that issue.
I just wanted to be sure that was
That's right.
Was made clear in the record. In the time I have left, which is about 8 minutes, I'd just like to ask you about several of the things that I believe you have written about. First is the 7th Amendment right to trial. I understand that you have written about that. Is that correct?
I have, Senator.
What are your thoughts about that?
Senator, I believe in juries. I liked trying cases to juries. I liked being on a jury. I think it's a part of our civic engagement that's really valuable. People feel connected to their government. Hamilton and Madison, I think it was, I can't remember which, in the Federalist Papers debated, is it a bulwark of liberty or is it the very palladium of liberty? That's what they thought of the Seventh Amendment. And I think it's just so difficult for litigants to get to a jury now. And we spend so much time in preliminary discovery, what we call discovery, motions practice. Lawyers become poets of the nastygram. They can write interrogatories in iambic pentameter. But there just aren't that many jury trials anymore. And I'm not sure that's a good thing.
Does this relate to your writings also about, or your concerns about access to justice?
Yes, Senator, yes.
Could you expand on that a little bit?
Well, when it becomes so expensive and takes so long to get to a jury, to get to a trial, some people don't bring good claims. A lot of people are left not bringing good claims to court. That's a problem on the one side of the V. And I saw that as a lawyer. And on the other side of the V, defendants, sometimes you feel like you have to settle, not because the case has merit, but because the cost and the delay to the client are so significant in getting to a decision. Just can't afford to do it. Got to get on. And as I indicated earlier, the American College of Trial Lawyers, and both represent both plaintiffs and defendants, have indicated both these problems are real in our system and need to be addressed.
Thank you. The last issue I'll ask you about is your thoughts, which you've already referenced somewhat, on overcriminalization in the law. Could you basically just reiterate that for us?
Yes, Senator. As I indicated earlier, I think the number is something like 5,000 federal criminal statutes on the books today, and hundreds of thousands in the Federal Register. That 8-point font, I need to bring out my reading glasses for when I pull open the Federal Register. And, I have a hard time reading it. And I have a hard time imagining the American people can read it, to be honest with you. And Madison warned about a world in which written law is lacking. And he also warned about a world in which we'd have too much written law, paper blizzard. So much so that the prosecutor can choose his charges with impunity, and the people don't have notice, really, what's expected of them. So I think both of those things on both ends of the spectrum are a concern. And Aristotle was right there, too. We're looking for a golden mean.
Well, and I think earlier today you also referenced maybe you meant to in these comments, the regulatory explosion of criminal penalties. Is that a part of this as well?
I would say it's been part of, I don't know about an explosion, but it's just a fact of life that's been with us for a while and growing.
Yeah, I won't ask you to comment on this, but I think it's an explosion, and not just in the criminal side, in the civil side as well, just the regulatory growth that we have seen in our government recently. This is not an issue for you, at least to discuss with me today, but I think we have a lot of difficulty simply because of the complexity that we are creating in our legal system. And many of those difficulties will need to be resolved at the policy level. I understand that. Judge Gorsuch, again, I just want to thank you for being willing to step up and do this service. It was notable to me, I think you said earlier, that Justice White only spent about 90 minutes in his hearing. Is that correct?
That's what I'm told.
Remarkable. Thank you again.
Enviable. No, this has been a great pleasure, a great honor to be here with you, Senator, and with all of your colleagues.
Well, we understand what you and your family and friends are going through. We know the commitment that you have made simply to agree to be nominated and move forward through this process. And I want to thank you for doing that as well. I truly do appreciate it. Thank you very much. And before I yield my time, I would like to ask unanimous consent, first, to enter a letter into the record from the President of the Colorado Farm Bureau endorsing Judge Gorsuch. Secondly, a letter from Todd Seelman, managing partner at the Denver office of, I'll probably mispronounce this, Louis Brisbois, Bisgard, and Smith in support of Judge Gorsuch's nomination. Another letter from the Lincoln's Inn Society of Harvard Law School, which is a number of people who know you from this group and who have commented on your humility, thoughtfulness, and intellect, which we have seen today. And then finally, an article from a Colorado District Court judge, John Kane, in which he rebuts basically the notion that there is any kind of ideological bias in your record. And I think says very positive things about Judge Gorsuch. I'd ask unanimous consent to put these documents into the record.
Without objection, the documents will be entered into the record.
Thank you very much.
From Hawaii.
Thank you, Mr. Chairman. The end is nearing for today, Judge Gorsuch. We've sat here for close to 10 hours now, and you have not told us your understanding of cases already decided by the Supreme Court, except to say that they are law and precedent. You have not told us your view of cases currently before the court, and you will not tell us your view on issues that might someday be presented to the court. In fact, you have provided us less in the way of answers about how you would approach cases than previous nominees to the Supreme Court. So how should we divine what you would bring to the Supreme Court in terms of your judicial philosophy? By looking at your judicial record, by looking at your writings? I see a pattern that is very much on a par with the Roberts Court's steady march toward protecting corporate interests over individual rights. That is not protecting the rights of the minority, as you told me in our meeting, which is the purpose of Article 3. So I hope that in answering my questions, you can provide some reassurances that you will be a judge or justice for all Americans. You had an extended discussion today with Senator Franken about your dissent in the Trans Am trucking case. I want to talk to you about another case, Longhorn Services Company v. Perez, in which you overruled an agency decision about worker safety. You were in the majority in a 2-to-1 decision. Could have gone the other way if you had gone that way, that overturned a sanction against the company based on a strained distinction between a floor hole and a floor opening. The dissenting judge, a President George W. Bush appointee, described this distinction as nonsense and said the distinction between a floor hole and a floor opening did not matter in this case because the company was in violation of an OSHA standard either way. Why did you believe it was appropriate to rely on a strained distinction between floor hole and floor opening at odds with the law's intent and purpose to protect worker safety?
Senator, I appreciate the opportunity to address that. As I think you've indicated, I was not the author of that opinion. I didn't write it. One of my colleagues wrote that opinion. Another one of my colleagues dissented. You're quite right about that. I don't have a dog in the hunt when it comes to holes and openings and floors, but apparently OSHA does. OSHA distinguishes between floor holes and floor openings when it comes to spaces.
Excuse me, Judge. That case held that you overruled the agency decision,
Yes.
which did not make a distinction.
With respect, Senator, OSHA regulations do make a distinction between, as I recall, it's been a while, but
Not in this case, sir.
Well, Senator, there are different regulations for floor openings and floor holes in, I think this is an oil and gas rig or maybe a fracking rig, and what you have to do in terms of remediation, cover or a handrail. There are different consequences, whether it's a hole or an opening, as I recall. And the party there, nobody was injured, but they got a fine for not doing, maybe covering it up, I don't recall. whatever the agency wanted them to do. And the question is whether they've been provided notice they were being charged with, whether it was a hole versus an opening. And Senator, all I was trying to do there, I agreed with my colleague who wrote the majority opinion, that OSHA charged what it charged, it had to prove, and that it can't change the charge in the middle of the proceedings, as I recall.
Well, the dissent indicated that this distinction was nonsense, and therefore
Well, that might be true.
Yes.
I mean, I don't know. As I say, I don't have a dog in that hunt. I'm just trying to apply the OSHA regulation.
If I can go on. So that law, though, was for the purpose of worker safety. And I think you responded to one of the questions from my colleagues that you do look to the purpose of the law, and that is what judges should effect. So the purpose of that law was worker safety. So I'm really not understanding why you went with the majority in making that kind of distinction. Let me move on. Earlier, you had an extensive discussion, as I mentioned, with Senator Franken about Trans Am trucking and whether you understood the impossible choice your decision would have given to the driver in that case, Alphonse Madden. And if your decision had been the majority, which it wasn't, it would have made a driver like Mr. Madden choose between endangering his own life and health or keeping his job. I'm hoping that you will share more about your approach to cases like transfer trucking. Your dissent dismissed the argument that the law should be interpreted in light of its purpose of protecting public health and safety, saying that those goals were too ephemeral and generic. Did the purposes of this law to protect an employee from being fired for acting in response to safety concerns play any role in your decision?
Senator, I appreciate the opportunity to talk about this again. The statute there protected individuals who refused to operate a motor vehicle. And at least as I saw it, and this is just one judge and how I saw one case in 10 years, and I saw that the individual drove away. He operated the motor vehicle. And so I didn't see how he could claim protection of a statute that hinges on a refusal to operate. I'm relieved to know that he was fine and was able to meet up with his employer 15 minutes or so later, as I remember the record. But my heart goes out to him. And I said that in the opinion, that he was put in a rotten position. And I go home at night with cases where sometimes the law requires results that I personally would not prefer.
I think that you could possibly have interpreted the definition or the requirement that he actually refused to drive the vehicle. He refused to drive the vehicle with the attached trailer. That's what but you could have held, I would think, that he refused to drive the vehicle in an unsafe way. So, I mean, the way I look at this decision, and you were not in the majority, is that if judges are going to work this hard to strain the text of the law to undermine the purpose, which was for the safety, and that a driver who made a decision based on that would not be fired, I think that makes it pretty tough for any laws that Congress passes or will pass to really be effective in protecting American workers. I'd like to turn to Citizens United. In this case, the court adopted a narrow view that only quid pro quo corruption counts regarding campaign contributions, and that appearance of corruption, basically, which had also been a concern, is out the window. This has unquestionably changed the landscape of our elections, unleashing a flood of corporate money in campaigns. If corporations are able to spend unfettered money on American elections, what is there to stop a foreign company from funneling money into our elections through its American subsidiary? For example, what limits would prevent a Russian oligarch from financing a $1 billion independent expenditure operation through an American middleman?
Well, Senator, I appreciate the opportunity to answer that. If I might, though, I just point to my record on employment cases. There are plenty of cases where I've ruled for the employee and not the employer. We can pick one and talk about one, but there are many, where I've ruled for the employee, even overturning the district court when the district court ruled for the employer. Lots of them. And I'd be happy to talk about any of them.
Well, I'm not.
But if we want
I'm
to...
not asking you about the others.
understand.
So
I understand
can you
that.
respond to my question about Citizens United and unfettered foreign money that can come into our campaigns?
Senator, I'd say that there's lots of room for congressional regulation here. And that, in fact, the Supreme Court has made clear that foreign money in particular is an area where Congress has substantial authority available to it. I would say this.
I'd just like a clarification then. You're saying that Citizens United leaves open for Congress to prohibit foreign money in our elections? Isn't that already happening?
Senator, I would say there's ample room in the area of campaign finance for further legislation. All sorts of room that the courts made clear remains. It struck down one law. That does not mean that every law will be stricken. It does not mean that Congress has no role. It means that Congress passed one law that, based on one record, the Supreme Court found to violate the First Amendment.
So since there's so much concern about foreign money and foreign governments attempting to interfere or really interfere with our elections, and if Congress were to pass a law that prohibited foreign contributions through middlemen or any other way, you would sustain that law?
Senator, I'm not making any promises to anyone about how I'd rule. I understand people would like me to make promises, but I just, that's not what a good judge does. It's not fair to the parties. I don't prejudge cases. It would be a violation of the separation of powers, in my view. It would be the end of the independent judiciary. Senator, what I would promise you to do is to look carefully at the record with deference to the fact finder, to look at the briefs, to go through the whole judicial process and carefully consider all the arguments made by both sides, as a good judge does.
Thank you. You've articulated that many times. The sheer volume of speech brought by corporate money drowns out the voices of everyday Americans on important issues. I'm concerned with influence peddling in politics, such as from billion-dollar donors like the Mercers or Philip Anschutz. Judge Gorsuch, given that you volunteered on numerous Republican political campaigns dating back to the 1970s, were you ever concerned with the flood of unfettered money in our elections and campaigns?
Senator, the first campaign I worked on, I was about 9 years old. It was my mom's. She was running for the state house. And I think it was, again, her idea of daycare.
So
that I'd walk with her.
I'm sorry, I have only 18 minutes left, and had you ever been concerned, because certainly you worked on political campaigns when you were beyond 9 years old.
I did.
Was there ever a time when you were concerned about unfettered money in our political campaigns?
Senator, I have lots of concerns as a person and as a citizen, but I'm now a judge. And my personal views have nothing to do with how I rule on cases. It's a discipline that a judge learns and exercises and hopefully improves upon over time. And I'm steadfast about that, Senator. It means the world to me as a lawyer and as a judge who cares about an independent judiciary. It comes from a place deep in my bones.
I'd like to move on.
Of course.
I listened to your conversation with Senator Coons about the Hobby Lobby case, and it's a decision that you joined in the 10th Circuit and was supported by the Roberts Court. And in that case, you decided that a corporation with 23,000 employees has rights to the exercise of religion protected by the Religious Freedom Restoration Act, and that it could use those rights to deny the thousands of women that it employed access to certain kinds of health coverage. And there was a notable dissent in the Supreme Court's Hobby Lobby decision by Justice Ginsburg, joined by the two other women on the Supreme Court. And Justice Ginsburg wrote, the, quote, the exception sought by Hobby Lobby and Conestoga would deny legions of women who do not hold their employees' beliefs access to contraceptive coverage. how much did you consider the significant need of the 23,000 Hobby Lobby employees, of which a significant number of them were women working paycheck to paycheck, for access to health care that they would now be denied?
Senator, I appreciate that question. The answer is I considered it very closely, very carefully. And so did the Supreme Court of the United States, which affirmed our court. And as you know, the Religious Freedom Restoration Act goes above and beyond the First Amendment in protecting religious liberties. It's a judgment made by this Congress that it's free to amend at any time if it wishes. It can eliminate corporations from coverage. It can eliminate the strict scrutiny that's required, and it can eliminate the act at any time. But, Senator, I gave every aspect of that case very close consideration. That was an en banc decision by our court.
You did write a concurring opinion on that.
I did.
And I think your concurrent opinion could even be deemed an expansion of the plaintiff's rights in that case. So in your view, the corporation did make claims about contraception based on religious beliefs which are directly contravened by scientific research. And by accepting as facts these religious beliefs and probing no further and agreeing that the corporation could deny coverage, the Hobby Lobby decision leaves us in a tough spot. So are there any limits? And if so, what are those limits on what a corporation may claim as a belief in justifying its denial of health care for its employees?
Senator, the sincerity of the belief, I believe, was undisputed by the government, at least in our court. So I just don't think that was at issue. Are there limits to how far the statute goes? Yes, there are. The government may force someone to forego and accept a substantial burden on their sincerely held religious belief if it can prove a compelling interest, which the Supreme Court accepted in this case, and can also show that it's the most narrowly tailored way to achieve that compelling interest. It's strict scrutiny. It's the highest standard known to law. And the problem in that case, again, as the Supreme Court and my court saw it, was that the government had managed to find a way to achieve its compelling interest in providing coverage to women in many other cases without requiring any compromise.
So I realize that the compelling state interest was conceded to the government, but my question really relates to the first part of the test, which is the sincerely held belief.
Yes.
And while that may not have been an issue in this case, even though if you were to look at their sincerely held beliefs, then there was evidence that some of their beliefs were scientifically not valid. So my question is really, how would you go behind the sincerely held belief to determine whether there's really a basis for this belief?
You're asking me whether I would, as a judge, decide that someone's sincerely held religious belief is wrong?
Well, based on scientific evidence or some other factual evidence?
So that I, as a judge, I just want to make sure I understand the question, that I would say that the belief is scientifically invalid and therefore not protected by the statute? Is that the question?
Well, therefore, could not be a sincerely held belief.
Oh, sometimes a court will hold that a belief is not sincerely held. That's true. That does happen. I've had a case involving just that scenario, and it involved a group of drug distributors who claimed they worshipped marijuana.
Yes. I was here when you responded to that.
Okay.
And, you know, I hate to be rude, but I'm down to less than 12 minutes. So if you don't mind, sir, I'd like to go on to another area. In 1942, an ordinary American took an extraordinary stand. His name was Fred Korematsu, who boldly opposed the forced internment of Japanese Americans during World War II. After being convicted for failing to report for relocation, Mr. Korematsu took his case all the way to the Supreme Court, and the High Court ruled against him. It took 39 years before a California judge overturned Mr. Korematsu's conviction in another proceeding, but the Supreme Court never overruled Korematsu. So Korematsu has joined the short list of the most regrettable decisions in the court's history. And even though most American citizens of Japanese ancestry were loyal, the court in Korematsu found that the government's curfew and internment program was constitutionally acceptable because some unknown faction or fraction of that group posed a special statistical risk of disloyalty and danger. Today, if the court were to assess special restrictions on U.S. citizens of Iranian, Yemeni, Somalian, Syrian, Libyan, and Sudanese ancestry, do you believe Korematsu would be applicable precedent for the court to consider?
No. And let me compliment Neil Gorsuch. When he was acting Solicitor General of the United States, he confessed error by the government in that case. That was an admirable move.
Thank you for that yes and no answer. I appreciate that. Going on to Hamdan. During a time as a senior official in the Bush Justice Department, you appeared to play a significant role in developing and promoting the arguments in Hamdan v. Rumsfeld, including the argument that the president himself had the power to set up military tribunals to try Guantanamo detainees without key human rights and other protections in the Geneva Convention and the Uniform Code of Military Justice. Judge Derek Watson, a Hawaii Federal District Court judge, recently issued a stay of significant portions of President Trump's second executive order banning nationals from 6 predominantly Muslim countries. And without commenting on the current case, do you believe that there are executive orders that are outside the scope of appropriate judicial review to determine if a president has overstepped his constitutional authority?
Senator, to me, one of the beautiful things about our system of justice is that any person can file a lawsuit about anything against anyone at any time. Any person has access to our courts of justice on any subject, and a judge, a neutral and fair judge, will hear it. I think that's a remarkable thing. It doesn't happen everywhere in the world.
Is your answer that there is no executive order that would not be judicially reviewable?
Well, Senator, a lawsuit can be filed on it. What a court will do with it is a matter of the judicial process, and we'd have to go through assessing what the claim is, what the defenses are, take evidence, hear the arguments, make a decision.
I understand. The court could say it's a political issue and not take it. Senior White House advisor Stephen Miller, who has been described as the architect of the Muslim ban, recently criticized the actions of federal courts in staying the initial travel ban on national TV. And Mr. Miller said that Donald Trump's national security decisions, and I quote, will not be questioned. I take it that you don't agree with Mr. Miller that there are areas like national security where the president's decisions, quote, will not be questioned even by a court, even by the Supreme Court. I take it you do.
Senator, I'll give you the same answer, that the beauty of our system, and I don't want to eat up your time, but the beauty of our system is that anybody can bring a complaint to court and have an opportunity to be heard under the laws of our land. It's a remarkable thing when you think about it.
The person who nominated you, Judge Gorsuch, does not have much judges or courts. As a candidate for president, and now even as president, he has belittled and berated judges who do not rubber stamp his views. He attacked Judge Curiel, his family's heritage, and his fairness while he was presiding over the Trump University fraud case. He sought to bully Judge Robart, who decided the first case challenging the constitutionality of his anti-Muslim travel ban. He sought to intimidate the Ninth Circuit and more recently has belittled Judge Watson in Hawaii for ruling in the second round of travel ban cases. These attacks are unfair because the judges cannot respond. Moreover, they provoke Donald Trump's supporters. Some reacted by declaring a boycott of Hawaii. All this because the distinguished federal judge in Hawaii gave weight to Donald Trump's own words about what he intended his travel ban to do. So I'd like to give you a chance to comment and either defend President Trump's statements on judges or condemn them. And there was a moment early in your nomination when you were reported to comment to senators that the president's anti-judicial comments were, quote, demoralizing and disheartening, end quote, but then you went silent even as President Trump escalated his attacks. I'd like to give you an opportunity to set the record straight. What is your view of President Trump's comments on judges?
Senator, I just discussed this with Senator Blumenthal a moment ago, and I'm happy to repeat myself.
Please.
I cannot talk about specific cases. That would be improper. And I can't get involved in politics. That'd be another violation of my judicial obligations. So I have to be careful. I have to speak in general terms. I'm not talking about any case or controversy. I'm talking about the independence of our judiciary. Right? Judges have to be tough. We take slings and arrows under bright lights. It's part of the job. And we take them from all sides, all day long, every day. Our job is to make decisions, hard decisions sometimes that people don't like. In fact, our job usually makes, I'm sorry, sir, I don't mean, it looks like you wanted to say something.
Yes. So Donald Trump's comments about the judiciary, while he may have focused on specific judges, indicate basically that he does not seem to respect the three branches of government as you do. So taken as a general proposition, if a president were to basically not give much credence or respect for the three branches of government, would you object to that president's comments?
Senator, I can talk about my record as a judge. I have tried to uphold the dignity of the judicial offices in the cases and controversies brought before me. When people, when judges have acted in ways that do not bring repute on the judicial office for making comments that are arguably improper. I've been on panels where we've replaced a judge who's done that. When lawyers fail to fulfill their obligations, I have commented when appropriate in cases and controversies properly before me. I've in fact even sent a lawyer to referral to the bar. Senator, I have worked to try and provide representation to individuals when I've seen pro se handwritten complaints that seem to me to have merit. I've appointed lawyers in those cases. That's my record as a judge, and I can assure you I am nobody's rubber stamp.
So when you were speaking about certain comments being disheartening and demoralizing, you were merely speaking broadly.
I don't think I was merely speaking broadly, Senator, with all
Or you were
respect.
speaking broadly.
Senator, I'm speaking about anyone.
You were speaking broadly.
Okay.
So Sean Spicer just tweeted regarding your comments on Trump's attacks on judges, which you said were disheartening and demoralizing, and Sean Spicer just said you were speaking broadly. Let's move on. In your 2006 book on the future of assisted suicide, you argued that Casey should be read more as a decision based merely on respect for precedent rather than based on the recognition of constitutional protections for personal autonomy, and that's in quotes, personal autonomy, or for intimate or personal, again, in quotes, decisions. So you wrote that in your book, but since that time, well, in fact, before that time, in Casey, the court relied on the protection for intimate and personal choices to decide many non-abortion cases, such as the, I always have a hard time pronouncing this, the Obergefell.
Obergefell.
You know which
I
case
do,
I'm talking
Senator.
about.
Yes, of course.
Thank you. Which recognized the right to marriage equality. Has the court's continued application of this right for personal and intimate choices changed your view that the Constitution does provide protections for intimate and personal decisions?
Senator, I've never expressed personal views as a judge on this subject, and that's because my personal views don't matter. Obergefell is a precedent in the United States Supreme Court. It entitles persons to engage in single-sex marriage. That's a right that the Supreme Court has recognized. It is a precedent of the United States Supreme Court entitled to all the deference due a precedent in the United States Supreme Court. And that's quite a lot.
So in your view, the Constitution does provide protections for intimate and personal decisions, and we shall see how far that constitutional protected right goes in other decisions. So basically what you wrote in your book is your personal opinion, and we can pretty much forget about it.
Senator,
not to be rude to you.
No, not at all. I'm not sure I tracked the question, though. I think it's me, not you.
Well, okay, let's move on. During the presidential campaign, Donald Trump laid out his litmus test, and I only have 42 seconds for nominating a justice. And he did say that he would want someone who is going to overturn Roe v. Wade, and that gun rights would be protected, making it pretty tough for Congress to pass what I would call sensible gun legislation, and that basically the religious rights of entities such as Hobby Lobby would be protected. So I said in my opening that it is, I would assume that you comported with the president's litmus test, otherwise you wouldn't be here. And do you think that you've provided us with any particular information that would cause us to believe, aside from your statement that you will be fair, that you do not meet these litmus tests? And because I've run out of time, you can provide that information to our committee.
May I respond, Mr. Chairman? Senator, I've been here for 2 days. I'll be here for a third.
Mm-hmm.
I hope I've given you some picture of my credentials, my experience, my track record as a judge. I hope I've given you some sense, too, that I have rejected litmus tests since the day I was a lawyer in print for judges. I hope I've given you some view into the way I think about the independent judiciary, about the sort of judges I admire, about the things that I think are important in our separation of powers. I hope I've given you some sense of my track record. 97% of the time, unanimous decisions. 99% of the time, in the majority. Been reversed maybe once by the United States Supreme Court. That's arguable in 10 years. I hope I've given you some picture of who I am and my record. No one else speaks for me, and I don't speak for anyone else, Senator. I really appreciate the chance to have this conversation with you.
Thank you. We'll see you tomorrow.
Thank you.
Also. Thank you, Mr. Chairman.
Judge, we've got going to give you the option of a 10-minute break, but instead of saying time certain of what would be 7:57, as soon as you get back, we'll get started, and we'll go to rodeo rules, which means I'm only you and Senator Kennedy, you're last, so we will make sure that we don't go over 8 seconds. In the West, you would at least understand that. So we'll adjourn. We will start no later than 7:57.
Thank you, Senator. I appreciate it.
Or not adjourn, recess.
So one more, is that it?
What's that?
10 hours plus into the day number 2 of the confirmation hearing for Judge Neil Gorsuch to be the 9th member of the Supreme Court. 2 more senators to ask questions. The last 2 Republicans, Tom Tillis, who's taken over the chair for Chuck Grassley, at least for the rest of the evening, and from the junior senator from Louisiana, John Kennedy. So last 2 questioners, they'll each get a half an hour. That will wrap up tonight. Judge Gorsuch will be back in front of the senators tomorrow. They'll start at 9:30 Eastern. And, of course, our live coverage will start at that time as well. We want to let you know we will re-air all of today's hearing coming up on C-SPAN right after things wrap up. Also, if you've missed any of the hearing, you can find lots of it, plus clips that people, viewers, and others have edited on our website at cspan.org. Again, they're taking about a 10-minute break here, and we'll be back with live coverage here on C-SPAN 3.
Call the committee back to order.
No, I'm fine, thank you.
Judge, my first very important question. Please pronounce your last name.
I've answered to a lot of things, Senator. Gorsuch is how I say it, but...
The reason I asked that question is we had probably 4 or 5 cheat sheets up here with different phonetic, so that is Gorsuch, right?
That's how I'd
say it. Press, it's Gorsuch. For everybody in the audience, it's Gorsuch. And I give my staff credit for actually getting it right, but I had a crisis of confidence when I saw the other cheat sheets. I want to thank you for being here, and Judge, I want to tell you, I grew up in the Southeast, and I love skiing. It's just never occurred to me to do it when the water was frozen.
Well, we'll forgive you that.
But I love the fact that you're an outdoorsman, because it means you love our environment, you love being outdoors, and you want to leave a good, healthy environment for your children and everybody's children. Senator Franken said that he had a career in identifying absurdity. I feel like I joined one when I joined the U.S. Senate. And I'm going to talk a little bit about that today. Yesterday I was saying I wanted to have you talk more and me less. I'm not sure if I can live up to that promise, because I want to go through a number of things. I'm a numbers guy. I like the fact that you've repeated the numbers and your track record on the bench. Best I can tell, if I double the number of cases that people have made at issue with you, that is 0.003 of your cases. 0.3 of, what is that, 1,000th of your cases are in question here. And I'm going to go back to those because they're fairly limited. But before I do, let me talk about another piece of absurdity. Absurdity would be talking about how President Trump set some sort of a litmus test and not recognizing that candidate Clinton told a town hall audience, I have a bunch of litmus tests. We have to preserve marriage equality, and we have to make sure Roe v. Wade stays in place. That sounds like a litmus test. I wouldn't have used that comment by a candidate if we were going with the President Clinton nomination. I don't understand why it's relevant here. It's not you. We're here to talk about you and your qualifications. Another absurdity that I think we'll see over the next couple of days is the absurdity of people saying that you're sidestepping the questions about cases that may come before you. I actually think you're following a code of conduct. You're following a code of conduct for United States judges, Canon 3A6. You're following the American Bar Association model code of judicial conduct, Rule 210, A and B. I appreciate you respecting and living what you say, and that's the rule of law and code of conduct of judges. Now I want to get into some specific cases, and I guess I'll start with freedom of speech. Judge Gorsuch, I'm going to read some of the notes because I want to make sure I get my points right. I want to apologize again because I may do a little bit of talking, but I do believe the First Amendment states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. I think the first few words mean something very significant, and I think that you do too. Now, clearly this amendment is not meant to limit the ability of the federal government to curtail free speech. It is meant. Do you agree that the founders intended this amendment to be a check on the federal government?
Senator, that's what it is.
Is it fair to say that the framers, when they were crafting this First Amendment, were concerned especially about political speech as opposed to, say, activity like exotic dancing or other speeches or activities that people argue are covered by the First Amendment?
The Supreme Court has held that political speech is the core of the First Amendment.
So it's fair to say the Supreme Court has routinely held that political speech, especially during a campaign for public office, is at the core of the First Amendment.
It has.
A lot's been said today about money in politics and a landmark case called Citizens United. Citizens United is a very popular punching bag for some of my colleagues across the aisle. You spent a lot of time talking about this with Senator Whitehouse earlier today. If you listened to them on the subject, you would think this decision resulted in the ability for a corporation to pump hundreds of millions of dollars directly into political candidates. The facts of the case get wrapped around buzzwords like dark money. However, I want to use some of my time today to walk through the facts of this case. First, at its very baseline, this case was a challenge brought to a federal statute. The federal government, through Congress, passed a statute aimed at limiting certain speech. And it was Congress's activities in regards to speech that the framers were concerned about. In fact, the statute prohibited entities such as corporations, including nonprofits, and labor unions from using their general treasury fund to fund any advertisement that used a candidate's name within 30 days of a primary or 60 days of a general election, including to promote a movie, as well as many express advocacy communications. This case had nothing to do with direct contributions and spending coordinated with specific campaigns and candidates. In other words, this case is not about corporations making direct campaign contributions at all. Citizens United was about an entity's ability to speak independently of any candidate or campaign. Judge Gorsuch, do you remember what behavior was in question, or in other words, what the Citizens United wanted to advertise?
Well, as you say, Senator, there was a movie involved.
It was a movie. Available on demand and home. The organization wanted to broadcast the film or to advertise the film before a 2008 Democratic primary. The federal government went into court and said a nonprofit couldn't produce or advertise a movie highly critical of a candidate. Judge Gorsuch, are you familiar with the oral arguments of the case?
I remember listening to them on tape at one point, but it's been a while since.
Well, during the initial oral argument for the case, the government was asked whether or not the same law could prevent a company from publishing a book that was the functional equivalent of expressed advocacy. Specifically, Chief Justice Roberts asked if it's a 500-page book and at the end it says, "So vote for X," the government could ban that? The response from the Deputy Solicitor General, who was defending the statute, stated, "We could prohibit the publication of the book." In the oral arguments, Justice Souter stated, "To point out how far your argument would go, what if a labor union paid an author to write a book advocating for the election of A and defeat B? And after the manuscript was prepared, they went to a commercial publisher, say Random House. And Random House says, yes, we'll publish that. We're talking about how far the constitutional ban would go. And we're talking about books. The Deputy Solicitor General said the labor union's conduct would be prohibited. He goes on to say, I think it would be constitutional to forbid the labor union to do that. I want everybody here to know, and everybody who's listening, to realize the consequences of this position. The government at one point defended the statute by saying it could prevent the publication of a book by a corporation like Random House if the book advocated for or against a candidate. That's not the end of the story. The Supreme Court was shocked that the federal government would take this position and ordered re-argument. Then the Solicitor General, Kagan, slightly retreated from the government's position. Then Solicitor General Kagan said that while the law could apply to a book, the government had not applied it in the past. But when asked again by Chief Justice Roberts about a pamphlet, she responded, I think a pamphlet would be different. A pamphlet is a pretty classic electioneering. Again, I want everybody listening to realize what we're talking about here when we talk about Citizens United. They argue that there was a constitutional authority to actually prevent the publishing of a pamphlet opposing a candidate if produced by a nonprofit organization. If we as a country have a long history of people being able to criticize the government, which includes specific offices in government. Sometimes this was done anonymously because disclosing the speaker's identity had serious implications. Whether it was the American Revolution, the Jim Crow South, or today. Therefore, we must be cautious in giving the federal government, including the executive branch, power to limit or penalize core political speech. Judge Gorsuch, you may not be able to see that. Do you recognize this book?
I can't see it.
We got this from the Library of Congress. It's actually, it has a number of Paine's writings, including Common Sense and other political writings. In this pamphlet, he urged American colonies to declare independence and sever ties with the British monarchy. What some of my colleagues from the other side have attempted to do is tie you to a court case which you had nothing to do with. They painted a picture of this case as support for big money in politics where big corporations win and the voter loses. In reality, the facts of this case were much different. The federal government argued it could stop a movie because it contained political speech. Then it argued it could ban a book because it contained such speech. Then it argued it could ban a pamphlet because it contained such speech. That's the Citizens United case. I find it curious my friends are so concerned about executive power and not concerned about the federal government arguing its authority to prevent production of movies, books, and pamphlets. It's foundational to our democracy. So as I stated previously, they're attempting to link you to Citizens United and continue a narrative that I think is absurd, that as a judge, you will support big money and corporations and never side with the little guy. The facts dispute that. The number of cases you've heard dispute that. Now, I want to close out here with a little bit of discussion about some of the discussion about maybe your political positions or your past being instructive to the decision by some as to whether or not they should support your confirmation. Let's talk a little bit about now Justice Kagan on Citizens United as the Solicitor General. Let's keep in mind, and actually the reason that this came to my attention today earlier when people were asking about the role that you played when you were working as an attorney on behalf of the government. So who was your client?
The United States.
So let me go back to when Justice Kagan was in a position. When she was nominated, she was a lawyer at the Department of Justice. In fact, she was the Solicitor General. As we've talked about, she argued with Citizens United. Now, she pressed the argument that the government had the authority to prevent the publication, not only of movies, but other forms of political speech, like Common Sense. She accounted for her arguments as Solicitor General this way, her quote, "I've tried very hard to take the cases and to make the decisions that are in the interest of my client, which is the U.S. government." My guess is that's what you were doing when you were in a different role representing the U.S. government. So I don't think there's much power to the arguments if for some reason you advocated for the government, unless we want to go back and revisit now a Supreme Court justice's history in the same. I think that what she did was fine. Whether or not I would have voted for her, we'll never know because I wasn't here. But I also want to bring up one other thing. Another member brought up an email sent to you in 2004 where you noted that you had volunteered on a political campaign. Well, once again, you may recall that Justice Kagan also had quite a political career before she became judge. After she was nominated to the Supreme Court after reviewing her emails from the Clinton White House, the AP published a report saying that as a White House aide, she had a flair of political tactics, a flair for political tactics, and often had to place political considerations before her political views. And the LA Times reported she worked in the research department defending Democrat candidates from political attacks and conducting research on the opposition. I don't think there's much more to say about it either, except to say this. In spite of her position to think that things like common sense could actually be, banned, in spite of her political activities that seem to have reached to a far greater level than your own, when she came before this Senate, a majority of Republicans, or I should say non-Republicans, joined with Democrats and through unanimous consent did not force cloture. They moved on to the vote, and quite honestly, Republicans were in a position to halt her, and I'm sorry, that's on Sotomayor. On Kagan, same thing. I had the wrong sheet up. On Kagan and on Sotomayor, Republicans respected the president's authority to appoint a Supreme Court justice, and Republicans did the right thing by moving forward and allowing the confirmation. So, I think that we have a moral high ground here that my colleagues on the other side of the aisle should take note of. Now I want to get to other stuff. Judge Gorsuch, I want you to go back briefly. I've got 15 minutes, and I'm going to go really quick. This will be a lightning round. The ethics class. This is another, I'm going to go back to absurdity. I appreciate that Senator Franken mentioned what he did because it's a perfect theme for my line of questions. I heard, and there's going to be a lot of it spun in the press, and I want to see if maybe a few people will actually listen to the answers to these questions. It had to do with the letters that came from the class that you teach on ethics. Can you tell me again exactly, in brief, you discussed a curriculum, a question that's raised in there. Can you very briefly, in about 45 seconds, kind of summarize that?
I can try, Senator. I'm very heartened by the fact that scores and scores of my former students have written this committee in my
And I'm going to seek a unanimous consent to put some of those letters into the record.
And over the last 7 or 8 years, I've used the same textbook. You can take a look at the teaching manual, and you'll see exactly what we discuss.
So it wasn't an arbitrary comment. It wasn't something that was done in this one segment. It was something that was a part of a well-thought-out curriculum, and it started a discussion that I have letters that, without objection, I'd like to submit to the record that suggest the same. But it wasn't something, it wasn't arbitrary. It wasn't off the cuff. It was something that was a part of a curriculum that had existed for how long?
7 or 8 years,
okay.
Senator.
Okay, so I think I'd like to seek unanimous consent that that I can actually put forth a series of documents that have to do with some former students, speaking specifically to the letter that you were informed of the day before yesterday. And other students that were in your class that saw the facts differently, and some other documents that I think will be good reference for the other members to review without objection. Okay, now I want to move into a couple of things that I really want to get to. The Trans Am trucking. First off, you've given me hope that I could actually understand legal opinions when I read them, when they're well written, and yours were. One of them was your dissent on Trans Am trucking. These are things, you know, people talk to, you're not here to have heart. You're here to judge the law. You're here to judge the Constitution. And I appreciate that about you because I suspect you've got a really big heart. But I thought it interesting, I highlighted several parts in your dissent. One was when they suggested that he should drag the truck and instead of keeping it there or leaving it there, your parenthetical comment, that was an illegal and maybe sarcastically offered option. So you didn't consider that a viable option. There are going to be people here that said that you were okay with that. That's wrong. It's absurd. And then the other one was he could sit and wait for the truck to arrive, and you parenthetically said a legal if unpleasant option. You went on to say in your dissent, it might be fair to ask whether Trans Am decision was a wise or kind one, but it's not our job to answer questions like that. Our only task is to decide whether the decision was an illegal one. And then you go on to say that there is simply no law anyone has pointed giving employees the right to operate vehicles in a way the employers forbid. I think that if you go back and people read these dissents, it's hard for me to imagine that you arrived at this through any other conclusion but for the fact that Congress had not explicitly provided you the authority that you thought you need or the reference point that you thought you needed to judge otherwise. And my guess is when you rode home that night, you wish that they probably had. Now, I also thought what was interesting in your dissent on the last page is you actually, kind of gave some suggestions to maybe how things should have been done differently or how we should have done our job better so that maybe you would have in a position to come up with a different judgment. But that's our job. You told Senator Whitehouse, it's not my job to do your job. That was one of your best quotes of the hearings today. And you're absolutely right. It's our jobs to make value judgments. It's our jobs to get votes and our jobs to answer to the American people every time we get elected or go to campaign every 2 years or 6 years. So I, for one, think that you came up with a well-reasoned, fact, legally based dissent on Trans Am trucking. Now I want to move to one that I just want to make sure I have time to get to because it's one where, quite honestly, I would have completely loved for you to go the other way, but you did the right thing. And it's purely by coincidence, and it really is. I'm wearing an autism pin today. Because I'm a big advocate for autism and Autism Speaks. I don't have any personal family experience with it, but it's something to me that's very important. And so, obviously, in Thompson, RJ2 School District versus Luke P., you all came up with a decision that was contrary to what I'd like to do for parents and families and children who have children with autism who are in the public school system and not getting the results that they would hope to get. And in this case, again, I think you got the IDEA absolutely right. There was not anything in the law that could have possibly led anyone. Somebody made reference to it in the opening comments. That's why I looked into it yesterday. But there's no way that you could have reached that far to support what clearly had to be, in this case, it was appeal, that would have been sympathetic to Luke P. and his parents. You made the right decision. You know what I did in North Carolina? I changed the law. I did my job. You made it very clear that the IDEA didn't do it, so as Speaker of the House, we went in there and when we said that a parent, after spending a year in public school, didn't think that their child was getting what they needed, then we would actually allow them to go to a private school and have money follow them so they can do it. So by doing my job, we've got a few hundred kids now who are getting the education that they need in a private school setting. Thank you for forcing me to do my job. It preceded my time as Speaker of the House, but we knew we'd run into problems there, and we solved the problem. Thank you for making us do our jobs. And then finally, the case, I want to go back to this real quick to make sure I get my notes right. Oh. Speaking or talking against, one thing I like about you is sometimes your decisions seem to make everybody mad, which is probably means it's a pretty good decision. So I think sometimes maybe you even exceed the 50% rule. Like the case in
My daughters would agree with you.
Like the case in Riddle versus Hickenlooper. I mean, that's a position where the Democrats and the Republicans were spitting mad at you. Mm-hmm. And there aren't many more. I mean, when you put every other minority party that was being treated unfairly as a result of actions that were taken. I don't know if it were Democrats or Republicans in control when they passed that. But that was a classic example where you obeyed the law. The other thing that was interesting, or you respected the law. The other thing that was interesting about that case is you actually provided some food for thought on how maybe they could solve that problem that would be constitutionally sound. And I've found that in other examples. I love the fact that you don't believe that judges, after they've heard the arguments, should go back and create new arguments to arrive at a decision. In your dissents and in your opinions, you basically say they never, and I think that was in Trans Am, that they made a reference. You said you had a thought, you thought about that. Trans Am brought forth Chevron briefly. Nobody else did. And you were making a comment, y'all should have done that. Not a bunch of judges in a room when they're deliberating, but when they're making the argument. So I think you were giving them food for thought. That is extraordinary that you would do that kind of work. That's why you're going to make a great judge on the Supreme Court. And that's why I fully support it. And I will call out absurdity every time I hear it this week and next week. I will ask my colleagues to do what Republicans did before I got here. Respect the president's right to seat somebody at the Supreme Court. They don't have to vote. I've voted for cloture on nominee, attorney general that I didn't vote for. But I respect this institution and this process enough to let it go forward. So I'm going to work very hard to support you. I could, you know, I'm not an attorney, so if I said anything illegally wrong, I did stay at a Holiday Inn Express a few weeks ago, but outside of watching Law and Order every once in a while when I get home late and unwind, I don't really follow the law, but I can tell based on a man of extraordinary patience. Yesterday I mentioned that I thought your at-rest heart rate was about 4. I saw it spike up 50%, maybe to 5 or 6 today. But I'll leave you with this. Peyton Manning, who I love, he went to the University of Tennessee, and then he tarnished career by going on to the Broncos and beating the Panthers in the Super Bowl. But let me tell you something that Peyton, I love Peyton Manning. In fact, I've got a quote on his wall that I make my staff look at every day. And it says, pressure is something you feel when you're not prepared, when you don't know what you're doing. You clearly know what you're doing. You haven't exhibited 1 iota of pressure. That's what's going to make you a great judge. The respect that you've shown when disrespectful questions were lobbed your way was remarkable. And I appreciate you being here. I appreciate your patience. And I'm going to yield back the rest of my time. But I will say that the break after 7 o'clock tonight also doesn't replace date night. So you owe your patient wife a good dinner after all this is done. But thank you, and I yield back the rest of my time. The senator from Louisiana.
Senator, thank you.
Yeah, and by the way, you didn't get to talk much, but I promise tomorrow you get to talk a lot.
I've heard myself speak more today than I'm accustomed to.
The senator from Louisiana.
How you doing, Judge?
I'm great. How about yourself?
You're that close to being done, that close. I think you've done pretty well today. And I just want to go on record as saying this is an important nomination. And I appreciate all the questions asked today, even the ones I disagree with. I didn't know what to expect. I mean, this thing could have turned into the Gong Show real easily. It didn't. And I appreciate that. I want to ask you a couple of questions, some things that maybe we didn't get to talk about much. First, why have you recused yourself in almost 1,000 cases?
Well, Senator, in the 10th Circuit, we have procedures.
Mm-hmm.
And one of the procedures is we make a list of all potential recusal possibilities. And for me, it was significant because I had been in the government at a position where we oversaw a number of different litigating units. That causes a fair amount of recusal right there. And, Senator, I was blessed with an active and robust practice and partners who went on to do much better without me than they did with me. And they had a lot of clients. And it was my view as a circuit judge that I didn't want to cause an unnecessary recusal problem later. Sometimes after a court decides a case, a recusal issue pops up. Judges miss things. We're human. It happens. The problem when that happens, of course, is then you have to get a new judge in and start everything all over again. That's a cost to the system that's not insignificant to your colleagues and taxing on them. And it also raises questions, of course, to the parties who have to start all that over and cost them money and time. And I did not want to create that kind of problem for the litigants and for my colleagues. And so I set up a process consistent with the practice of my colleagues. I talked to my colleagues about how they do it and tried to conform to the practices of the 10th Circuit as best I could. And as you know, most of the recusals are not really, I mean, recusal is not even the right word, they're screened out
Right.
by the clerk's office before they ever get to me. We're on a wheel.
Right.
And so I just get the next one on the wheel. Everybody gets the same workload. Doesn't
Right.
affect our workload, but it does affect confidence in the judiciary. And
The recusal rules are different from the U.S. Supreme Court, as I appreciate it.
yes, Senator.
Okay. I want to ask you about the relationship between the United States Constitution and a state constitution and the interaction. And let me get specific so you'll understand what I'm talking about. I think this is well-settled law. A DWI, we call it DWI in Louisiana. Some states call it DUI, but a DWI roadblock. I think it's well-settled. A number of cases, U.S. Supreme Court, that says a DWI roadblock, so long as you use neutral criteria, it's perfectly permissible under the Fourth Amendment. If I say anything wrong, stop me. It's clearly a seizure, but as long as you have neutral criteria. Do you remember why the Supreme Court made that decision?
I'm sure you're going to tell me, Senator.
Well, if you don't know, my understanding is that the Constitution only protects against unreasonable searches and seizures.
Right.
And the court balanced the public interest versus the extent of the privacy violation. But let's suppose, so that's well-settled law. You can, under the federal Constitution, you can have a DWI roadblock. Let's suppose the Supreme Court of Massachusetts, I wish Attorney Franken was here, said, you know, we appreciate that, and we appreciate that's federal law, but we have a Fourth Amendment in the Massachusetts Constitution, and we want to go further, and we want to outlaw roadblocks. We want to give more protection. We don't want to take away protection that our citizens have under the United States Constitution, protection from government. We want to give them more protection from government and no roadblocks, period. Do you think that's permissible?
Senator, generally speaking, decisions based on independent and adequate state grounds are permissible. Mm-hmm. The primary precedent in this area is Michigan versus Long, mm-hmm. A decision by Justice O'Connor. The state has to make clear that it's deciding on independent and adequate state grounds and not resting on the U.S. Constitution. If there's some ambiguity, we may, as federal judges, consider it to be a decision based on federal law. But a state is free to add to the liberties of the people, generally speaking.
Mm-hmm. Well, what if the adequate and independent state grounds aren't clear? What do you do?
Well, that's Michigan versus Long, and there's a precedent, and there's a test for it. Mm-hmm. And again, if it looks like it could have been on the decision could have been made on federal grounds, then the federal court will examine it on that basis. State court makes clear that it's independent and adequate state grounds, well, then state law controls.
Do you think it makes sense? I mean, isn't the law complicated enough? Do we really need 50 rules for DWI roadblocks?
Well, Senator, that we have this thing called federalism.
I've heard of it.
Yeah, I figured you might. And it's part of our separation of powers. And it's part of how we preserve liberty. Mm-hmm. Right? We diffuse power to protect liberty. And federalism is a key part of it.
Okay. I haven't read all your cases, but I haven't seen many where you dealt with substantive due process or equal protection. So I want to talk about that for a few minutes. If you have a case where you don't have a fundamental right or fundamental liberty, and you don't have a suspect classification, so you're not going to use strict scrutiny. You're going to use the rational basis test, which means you're going to uphold the statute if the legislature has a rational reason that's connected to a legitimate goal. How far do you go? How closely do you think federal judges should examine what the legislature does? Is it a rational reason? Is it any reason? Do you make up the reason for them? Have you ever heard of rational basis with bite?
I have, Senator. And before we get to that, I think it's important to acknowledge there's also intermediate scrutiny.
That's true.
For example, many gender cases.
For gender, but I'm talking about just plain old variety, no gender, no race, no kind of special heightened scrutiny, just rational basis.
The Supreme Court has indicated in what you're describing as rational basis with bite that sometimes if there's a discriminatory animus present, even though there might be a legitimate rational basis one could conjure for the rule, that might fail strict scrutiny, Senator.
Mm-hmm. What does the rational basis test mean to you?
Well, generally speaking, usually speaking, it means that if there's any rational reason that one can conjure for the rule, it stands out of deference to the legislative process.
Does it have to be a good reason?
It has to be a rational reason, not one that I find personally persuasive, but one that someone could find persuasive.
Okay.
That's out of deference to the lawmaking process of this body, Senator.
I understand. I want to ask you about the Trans Am case. It's been talked about a lot. You dissented. Pretty tough facts. Your dissent probably, I guess, made you about as popular as cholera.
Seems so.
Yeah. But as I understand it, you just looked at the statute. And tell me what the statute said again.
It said that an employee who refuses to operate a motor vehicle has certain legal protections from firing.
But he didn't refuse. He operated.
That's what I thought the facts suggested, Senator.
Well, I thought about that case when I was reading a case of yours that I commented on yesterday. AMV Holmes. I love this case. Pretty recent, last year. And as I appreciate it, the majority opinion was kind of tough to get through. It was like 95 or 100 pages, but 13-year-old kid, 7th grader. He's fake burping in class.
He is.
And he's pretty good at it.
He's very good at it, apparently.
He disrupts the whole class.
He
so
does.
The teacher takes him out, sits him down in the hall, calls the assistant principal. She calls the police officer, I guess, assigned to the school. They can't take him to the principal's office, and the police officer arrests him. And kid's mom sues. I think it was a 1983 action, if I recall.
That's right.
His mom sues. And the majority held qualified immunity. And this is the way you described the case. If a 7th grader starts trading fake burps for laughs in gym class, what's a teacher to do? Order extra laps, detention, a trip to the principal's office? Maybe. But then again, maybe that's too old school. Maybe today you call a police officer. And maybe today the officer decides that instead of just escorting the now compliant 13-year-old to the principal's office, an arrest would be a better idea. So out come the handcuffs and off goes the child to juvenile detention. My colleagues, the majority, suggest the law permits exactly this option, and they offer 94 pages explaining why they think that's so. Respectfully, I remain unpersuaded. But it's your last paragraph in that opinion that made me think of Trans Am. You went on to explain why you interpreted the statute to be contrary to the majority opinion. But this is how you wrapped it up. Often enough, the law can be a ass, a idiot, quoting Dickens and Oliver Twist. And there's little we judges can do about it. For it is or should be emphatically our job to apply, not rewrite the law enacted by the people's representatives. Indeed, a judge who likes every result he reaches is very likely a bad judge reaching for results he prefers rather than those the law compels. So it is I admire my colleagues today. For no doubt they reach a result they dislike but believe the law demands. And in that I see the best of our profession and much to admire. It's only that in this particular case, I don't believe the law happens to be quite as much of an ass as they do. And I respectfully dissent. Is that what happened in Trans Am?
That's who I am, Senator.
Can you tell me something that you think is a good idea, but you think is unconstitutional?
Oh, Senator. It's been a long day.
I know. And you're this close to CSI.
No,
okay?
no. Senator, I've loved every minute I've spent with you and with all of your colleagues. I'm sure I could conjure something.
All right, we'll think about it tonight.
But Senator, I wouldn't opine on it if I could. It's just not my job. It's just not, my job is, as you just read it, that's how I see my job. Right? And I respect my colleagues who see it differently, because they did. They wrote a 94-page opinion in that case, a thoughtful one. And I respect them deeply. And the same thing in Trans Am. Right? Sometimes the law is what it is. And they see it one way. I'm sorry, Senator.
No, you go ahead.
No, we just do the best we can, day in and day out, in cases like these. And nobody hears about it. And it's the quiet work of judges trying to get it right.
And that's why I enjoy your opinions, aside from the fact that they're well written. You kind of play outside the pocket. I mean, you adhere to the written word, which is what I want to ask you about next. It's clear you don't like labels. Okay? You wouldn't call yourself an originalist.
Senator, I'm happy to embrace that. I don't reject it. I just am concerned about the level of our discourse in this society today, when we're often quick to dismiss one another, Republican, Democrat.
That's fair enough.
Whatever.
That's
not the world I care to inhabit. I care to inhabit an idea of respectful engagement of ideas with every person who comes before me. I do believe the original understanding of a text is very important to a judge, and I do believe any good judge wants to know that information, and I do.
And I believe the phrase you use is the original public understanding of the Constitution.
Yes, Senator.
What does that mean?
It means I'm not looking for hidden intentions, I'm trying to get inside, respectfully, your head. I'm looking for the words you use, trying to understand what they mean, what a reasonable person at that time would have understood they mean. because that's the fixed meaning I can latch on to and say, I'm enforcing that, not my will.
Is it the meaning of the drafters in 1787?
No.
Or is it the meaning of the legislators who approved the Constitution? Or is it the meaning of the general meeting of the people? What if they didn't contemplate it?
Senator, they don't contemplate a lot of things that arise.
Mm-hmm.
Equal protection of the law, unreasonable search and seizure. These are broad terms, but we can give them content by looking to what the original understanding at the time was, right? What a reasonable person would have understood them to mean. The fish case in the statutory construction scenario. What would a reasonable reader understand that to mean? And it serves a couple of important functions. First, it doesn't necessarily decide cases. It doesn't determine outcomes. And no one's looking to go back to horses and buggies.
I know that.
All right. What it does do is give us a way to communicate with one another that's neutral, that we're aiming at something outside ourselves as the basis for decision. That's part of the separation of powers. Not legislating, judging.
I get it.
Second, it's a due process concern.
I get it.
It's a fair notice concern. I can charge, I'm putting people in prison for long periods of time as a judge. I'm complicit in that. And I want to do it on the basis that I know that that person had fair notice of the laws that are applicable to him or her. That's important to me. And I think to all judges.
I don't mean to cut you off.
No, I'm sorry.
I just have to be mindful of the clock.
I'm sorry.
What's a penumbra?
Means not just the thing itself, but what surrounds it.
What's a legal penumbra?
Senator, that's a phrase that's been used in opinions by the court.
Do you believe there are unenumerated rights in our Constitution?
Senator, the Supreme Court interprets the Constitution, and that is a legitimate function of the United States Supreme Court. And in interpreting the Constitution, it necessarily declares in this case or that case, it sets a precedent as it interprets. I've come back to the GPS case because I think it's a wonderful example. Or Heller, it's another example. You can pick all sorts of examples where the court is interpreting a textual right in the Constitution or a statute.
Let me ask you about euthanasia. I didn't read your whole book.
I don't think many people have, Senator.
But I read enough about it, and I read a little bit of it. I believe you're an Episcopalian.
I attend an Episcopal church in Boulder with my family, Senator.
Yeah. I'm a Methodist. I was a Presbyterian, and Becky and I got married. She was Methodist. I was Presbyterian. We compromised, and I became a Methodist.
That's the way it works.
But as I understand your thesis about euthanasia, which you oppose, it's not really based on religious teachings. It's based on secular moral thinking. Tell me about that. That euthanasia, I mean, from one perspective, you know, if we have the right to control our bodies, if we have autonomy, privacy, and disclosure of privacy and all that, you know, this idea of self-determination, but you believe it can lead to something worse. Is that your thesis?
Well, Senator, this was in my capacity as a commentator before I became a judge.
Sure.
And as a student.
Right.
And when I was fortunate enough to get a scholarship to study law and a doctorate, I know you've spent some time thinking about similar things in a similar place. It struck me as an important and unresolved legal issue that deserves some thinking and a contribution where I could study and maybe add something to the discussion. Not that I have any great insights or perfect answers in this area. It's hard.
I don't think anybody does.
It's hard. I agree. I agree with that, Senator. And there, I expressed the belief that the conclusion as a commentator that the right to refuse treatment recognized in Cruzan by the United States Supreme Court was appropriate.
Mm-hmm.
People should be allowed to refuse treatment, go home, die in the arms of their family, rather than being poked and prodded. At the same time, I agreed with the Supreme Court as well, that the right of question of assisted suicide was primarily a state responsibility. And that's where Glucksberg and Quill, the Supreme Court, has left the issue.
Mm-hmm.
And then the question becomes, what do you do? It's a question we all have to face. Do you legalize it or don't you? It's a hard question.
If you legalize it, it cheapens life, doesn't it?
Senator, what I worried about is the least amongst us in those circumstances.
The unprotected.
My concern is that when you have a cheap option and an expensive option,
yeah,
people who can't afford the expensive option, they're the ones who tend to get hurt. The disabled, the elderly, the weak, minorities.
Yeah.
So those were my concerns. I might be right and I might be wrong. History will tell. And if I'm right, great. And if I'm wrong, yelling and screaming about it won't make me any better at it. It won't make me right. It was a contribution, part of a debate, part of a discussion. And I hope it was a respectful and useful contribution that at least one senator has read. And otherwise, and up until about a month ago, I think primarily occupied a very dusty bookshelf somewhere in a law library.
You prefer wet flies or dry?
Dry.
Dry. I do too.
Happy to express my view on that.
Do you use a floating line or a sinking line?
Well, with the dry fly,
You have to use the dry, but you don't use wet flies with a sinking line to go off those?
Well, I've been known to cheat once in a while, and the bead head might go on as a dropper underneath my dry.
Did you know President Obama at Harvard?
Senator, I knew him, not well. Our past, it was a big school.
Yeah. Was he one of those, like, front row guys that was always raising his hand, or did he kind of stay in the back row like I did and avoid eye contact with the professor so you wouldn't get called on? Or you don't have to answer that.
We were in different sections.
Oh, okay. All right. I just want to ask you one last one. It's about legislative intent. I've read where you've said that trying to discern legislative intent is a, quote, notoriously doubtful business, and I agree with that. I mean, legislators and congresspeople have a multitude of reasons for voting as they do. But that doesn't make it the search for legislative intent and looking at the legislative history. It may not be dispositive, but that doesn't make it useless. I mean, wouldn't you love to have a verbatim transcript of everything that was said at the, 1787 convention, 1789?
Senator, I respect very much what this body does. I hope my career, my body of work, reflects my respect for this institution. As a judge, I have to look at what's presented to me, and I look at everything that's presented to me, everything that's presented to me. I read everything that's presented to me. And I have used legislative history from time to time, as you've seen, and I know you read a whole lot of my stuff. I do worry when I'm putting someone in prison, for example, or involved in a ruling involving their liberty in particular, about charging them with knowledge of what happens in a committee room or a statement that might be presented only on the floor by one individual, rather than by the law that has suffered through the process of compromise, bicameralism, through both houses, and presentment and signature by the president, and goes in the law books. Hidden law can be a problem. I worry a little bit about that, particularly in the criminal context, Senator. It's a matter, again, of due process and fair notice. So those are the considerations that a judge, I think, always considers. What's fair in terms of due process and fair notice, at the same time being respectful of this institution and the hard work you do for the American people.
I don't know if you're a drinking man, but you may want to have a cocktail tonight. Just kind of relax. I'm done. Just don't drink vodka. Stay away from vodka for a while.
Senator, I'm going to hit the hay. Thank you very much.
You've never been to Russia, have you? I meant to ask that. No. Strike that. Strike that question.
I've never been to Russia.
Thank you, Judge.
Thank you,
Mr.
Senator.
Chairman.
Thank you.
Let's go home.
Thank you, Senator Kennedy. Judge, you're done for the day. We want to extend the thanks to you and to the fellow members who played it out. We'll start a series of 20-minute rounds tomorrow. And I, for one, will be here for every bit of it because you've taught us a lot today. And I think the American people should be very proud that we have somebody like you that's coming before this body and headed for the Supreme Court. We're going to recess tonight and convene again at 9:30 a.m. tomorrow morning. Until such time, we stand in recess.
Just over 11 and a half hours on day number 2 of the confirmation hearing for Judge Neil Gorsuch for the Supreme Court. 20 rounds of half-hour questions from the 20 members of the Senate Judiciary Committee, with another round tomorrow of 20-minute questions and our live coverage tomorrow as well. I want to remind you that we are re-airing the entire hearing, getting underway now over on our companion network, C-SPAN. And here's what's ahead. Senator Mitch McConnell earlier today in a news conference with reporters saying that the Senate will confirm Judge Gorsuch before the April recess, saying that Republicans had previously laid out the timetable, but it's noteworthy that Senator McConnell still believes the schedule is unchanged despite the workload senators are also facing with the health care overhaul.